All right, Ms. Boone, Mr. Boone has indicated that he attempted to follow up after one of our last hearings regarding the status of the application for visitation. He never heard anything, so he submitted another one on Friday, August 22nd.
Your Honor, am I allowed to expound on that?
Yes, you are.
Well, I know for a fact that I'm actually in the classifications department now, and as of this date, no visitation applications have been received on his end for himself or for my son, and no attempts also have been made in order for him to try to do so in the meantime. I know that our pre-trial conference was on May 29th, and you gave them a 2-week deadline to submit. And I believe also that his attorney even volunteered to submit them himself due to the prolongation of time for the now ongoing 9 months that I've been trying to get him to submit for no reason of him withholding submitting the visitation application. So that's why I put in my cross notice and again my motion for contempt at this point, because they have disregarded your verbal order or instructions to submit them within the 2 weeks as of May 29th.
Yeah, I know for a fact. I'm surprised you didn't say I know
Right,
for a
I'll have
fact.
counsel
and
respond.
everyone knows.
Yes, thank you, Your Honor. So in order for someone to be held in contempt, the court has to find that they willfully and intentionally violated an express and clear provision in a order or an agreement that was ratified by an order. I'm looking at paragraph 5 of the order that references this Department of Corrections application. And it says, respondent also raised concern about petitioner not preparing an application required by the Department of Corrections so that the minor child could visit her. There was no pending motion before the court on this issue, but petitioner did provide information to the court on his efforts in submitting the requested application, and he advised the court that he would attempt to follow up on the status of the application. There's nowhere in this paragraph where it gives gives Mr. Boone some sort of clear and express deadline to submit anything, or that he would be held in contempt or put on notice that if he didn't do something by a specific date that he could be held in contempt by this court. With that being said, Your Honor, I do understand that it's the court's wishes, and it's my client's wishes too, to get this set up as quickly as possible. Mr. Boone has resubmitted a second time now the application on the 22nd of August, according to his sworn testimony. I'm assuming that whatever Ms. Boone is seeing right now, maybe it's not updated in the system. I don't know what else Mr. Boone can do to address this concern, but certainly being held in contempt would not be an appropriate remedy based on the language of the order in question.
All right, I will allow you to briefly respond, Ms. Boone.
Thank you. After the pre-trial conference, he also was under oath as well and told the court that he made an attempt, and he has not made an attempt. Nonetheless, that was 3 months ago. And you did give them verbally a 2-week deadline. And again, verbally, his counsel volunteered to
All right, Ms. Boone, I cannot enforce any verbal statements that were not in an order. I specifically put in the order because there was no motion at the time. We did address it, and I did want there to be note that we addressed it, but there is no specific order requiring Mr. Boone to do anything by any specified period of time. And by law, because there is no order, I cannot hold him in contempt for failing to comply with an order.
Is there a way that
what you really want to know, and I hope this doesn't get him in trouble, but Brian is here legally. So do what you feel you must.
It's been 9 months that I've been asking from him to submit these visitation applications. There's no legitimate reason for him doing so. And I don't have any record of who he spoke to supposedly when he did try to contact DOC. And then also a confirmation that he's done it this time, 9 months later and under oath. How can I go about doing so to make sure that this is actually being done?
Hi, Kim.
All right. With that, I am going to deny without prejudice the motion for contempt I do not find that there is any willful violation of a specific court order with regard to a visitation application. All right, there was another motion that was filed by you, Ms. Boone, respondent's motion to appear in person for trial that was also filed on August 20th. I will hear you on that motion.
Well, I'm on the telephone, so it does me no good at this point, Your Honor.
All right, are you withdrawing that motion?
Such an asshole she is.
I am.
All right. All right, hearing that you're withdrawing that motion, I'm going to deny that motion as being moot. Now we can move on to, with regard to the petitions that we're here on today. And I'm going to start with the petition for relocation. Ms. Boone, do you oppose the petition for Mr. Boone to relocate with the minor child to?
I do not oppose.
All right, hearing that there is no opposition, I'm going to adopt the findings from the, I believe it was February 2023 order, finding that there was a substantial change in circumstances that necessitated Mr. Boone moving the minor child to, and hearing no opposition to the motion, the petition for relocation, I'm going to grant that petition.
Your Honor, am I allowed to say anything in
Chris?
regards to the contents of?
Contents of?
If you're not contesting it, I don't need to hear anything about it.
I am contesting some of the points that they have in regards to some of their other motions and modifications. Just things that I would like to apply to it from this motion.
All right, the petition for modification is solely for Mr. Boone to move to with the minor child. Are you opposing him moving to with the minor child?
Your Honor, you said the petition for modification, the petition for relocation.
Excuse me, the petition for relocation. We're not dealing with the petition for modification just yet.
Okay, no, I do not oppose the modification for relocation.
All right, so as I stated before, I'm going to grant the petition for relocation. Petitioner's verified petition to relocate that was filed on February 14th of 2023. All right, that puts us to the petition for, supplemental petition for modification.
Your Honor, if I may just have one question about the relocation petition.
Okay?
Does Ms. Boone also agree to adopt the proposed amended parenting plan that we submitted in regards to the relocation? Because
I do
that
not.
is still...
Okay.
I just need to know if I need to present evidence as to that point.
All right, so we will hear evidence with regard to the parenting plan. As it relates to both the verified petition to relocate and the supplemental petition for modification. All right, do we wish to have brief opening statements?
I would like the opportunity, Your Honor.
All right, so Ms. Boone, I'm going to hear brief opening statements first from the petitioner, and then I'll hear your brief opening statements. And again, we're only dealing with the issues on the supplemental petition for modification of alimony and child support. And I believe also you all wanted sole parental responsibility, is that correct?
Yes, Your Honor.
And then also the proposed parenting plan with regard to the relocation. Okay, once counsel for petitioner has done with their opening statement, I will give you an opportunity to also present an opening statement, and then we'll go right into evidence, okay?
Yes, Your Honor.
All right, I will hear petitioner's opening statement.
Do you mind if I go to the podium here?
You may.
All right, well, good afternoon, Your Honor. We're here today, as you've already outlined, on a petition to relocate and a petition to modify. I can cut out a lot of my opening statement because it sounds like Ms. Boone has agreed to the petition to relocate. What the evidence is going to support and what we are going to present evidence on regarding the parenting plan for the petition to relocate is that we are proposing that Ms. Boone have a 1 monthly visit with their 14-year-old son at the correctional facility that she's located in Marion County, and that she be also entitled to a minimum of 1 weekly phone call with the child. And we are also asking for sole parental responsibility regarding the day-to-day, or not only the day-to-day decision-making regarding the child, but also all of the decisions related to the child. We believe the evidence in this case, considering what has transpired since February of 2020, would support a order of sole parental responsibility when it comes to parental responsibility. I think the most contentious part of this case, Your Honor, is going to be the discussion regarding whether or not Ms. Boone is owed money. Our position is that, Your Honor, actually Mr. Boone is owed money, but he's willing to waive that and just to have both parties owe each other nothing moving forward. What evidence is going to show, Your Honor, is that since February of 2020, Ms. Boone has been incarcerated. She was charged and arrested for second-degree murder and has since been convicted by a jury of her peers of second-degree murder in December of 2024, and she is serving now a life sentence. Since February of 2020,
I like her hairstyle.
Mr. Boone has been 100% financially responsible for their now 14-year-old son. At the time that Ms. Boone was incarcerated, what evidence is going to show is that Mr. Boone stopped paying the $1,000 per month of alimony and the $100 per month in child support that was ordered pursuant to the June 15th, 2018 final judgment of divorce between the parties. Mr. Boone will testify, and evidence will support that for multiple years after the respondent was incarcerated in February 2020, Mr. Boone continued to give Ms. Boone financial assistance in the form of commissary payments, other payments, and also maintained a mini storage for her for multiple years after she was incarcerated, despite having absolutely no legal obligation to do so to maintain that mini storage. What evidence is going to show is that when she was incarcerated, actually, Mr. Boone helped her remove her stuff from the apartment that she was living in at the time, and was really one of the only people that assisted her during that time and acted in good faith to help the mother of his child during that time period. What Mr. Boone is going to testify to is that throughout that time period, he averaged about $600 a month in direct payments to Ms. Boone and also in-kind payments towards expenses that should have been Ms. Boone's obligation. Also, what evidence is going to show is that since February of 2020, Ms. Boone had approximately.
So, you know, I'm here, finally got this up. I looked down at my phone, which is what you may have noticed. I just kind of like leaned back and I was all entranced. I got a text from Danielle Chavon, and she was like, girl, look at your last video. She means the one I just tried to put up, you know, and she's like, you have to unlist ASAP. I can hear you cussing. I can hear ambulances. I did just unlist it. I mean, not that that's the worst, but it's, you know, it's not that professional to. All right, now everyone's getting in the mix. Let's carry on, shall we?
Approximately a $370 child support obligation to Mr. Boone. And the reason why we believe evidence will support this is that under Florida Statute 6130, subparagraph 11, subparagraph C, despite the fact that the petition to modify was filed in April 12th, 2022, that the court is within its authority to modify child support retroactive to the date a parent first failed to exercise their time sharing pursuant to the final judgment. Ms. Boone, pursuant to the final judgment, had an equal time sharing schedule, and then, of course, in February of 2020, that time sharing went down to 0, and she had 0 overnights. She's had 0 overnights ever since. So therefore, the court can go back to February of 2020 and consider what the child support obligation should have been, considering that she did not exercise her time sharing, and give Mr. Boone a credit for what the child support should be. And we'll be presenting evidence as to what we believe that number should be, imputing minimum wage to Ms. Boone and also imputing $60,000 a year of income to Mr. Boone, despite the fact that he's currently unemployed. Also, Mr. Boone, since Ms. Boone was incarcerated in February of 2020, has accumulated over $14,000 in attorney's fees trying to modify the final judgment and trying to be able to successfully relocate his son to Gainesville. This morning was the first time that Ms. Boone has made any concessions regarding any of the outstanding motions that were filed by Mr. Boone and the petitions that were filed by Mr. Boone, despite having really no articulable argument against the relocation. And the court should note that in the order on temporary relocation that was entered by a predecessor judge in this case.
Hi, Anwar. Hi, Appalachian. Hello, people. I want to say a quick hello and ask you if this is better on my mic, if you can hear me better, just in case I have something to say, because, you know, I only talk when I have very important things to say. And Beaches, I'm with you on that handle of Woodbridge. Not yet, though, because I had to have my compos mentis to set this up. All right, let me know.
Articulated that Ms. Boone, even at that hearing, seemingly had no articulable reason to object to the relocation, yet she still has forced this final hearing and forced Mr. Boone to incur attorney's fees for another 2+ years while we continued to litigate this matter. So another thing that we believe evidence will support and what we're going to be requesting here today is that the court take into consideration in its equitable powers the amount of attorney's fees that Mr. Boone has incurred to fix basically all the chaos that occurred due to Ms. Boone's voluntary act, criminal act, and also her ongoing defiance and unwillingness to acknowledge the reality of her situation and the reality of this family's situation, which has had a direct result in Mr. Boone having to incur tens of thousands of dollars of attorney's fees. And so if there is, even after the consideration of the payments that were made to Mr. Boone, from Mr. Boone to Ms. Boone during the period after February 2020 moving forward, the retroactive child support that Ms. Boone ordered, if there still is potentially a retroactive alimony amount this court is considering, we are asking that the court also, in its equitable powers, consider the $14,000 in attorney's fees that Mr. Boone had to occur, and that the court would apply that to any potential technical arrearage that Mr. Boone might have.
Got it, Kim. Thank you for letting me know, because I've kind of been wondering that, but, you know, I don't want to pause just to ask that, which is stupid on my part, but good to know.
And when we say technical arrearage, Your Honor, you know, technically speaking, while child support is retroactive can be retroactive to the date that a parent stopped exercising their time sharing, alimony modifications are only technically speaking retroactive to the date that a petition to modify was filed. And so we're looking at that basically 26-month time period between February of 2020 and April of 2022 when modification was filed. It's also important to note, Your Honor, that evidence is going to show from the date that that petition was filed moving forward that it is appropriate to terminate Ms. Boone's alimony obligations obviously, or alimony award, excuse me, because she has no need for day-to-day living expenses when she's incarcerated and having the state pay for her day-to-day needs. And so it is appropriate to terminate alimony from April of 2022, and also to give Mr. Boone a credit. And we'll be presenting evidence on that. Also, we're going to be presenting evidence, Your Honor, as to a sum of money that is currently being held with the Orange County Clerk of Court.
Brian. Hi, hear me out. So I want to share this with you people because when I had to go on to YouTube Studio to privatize my latest attempt at this live, where I got a desperate plea from Danielle telling me to unlist it because you can hear what she calls as my private sounds, which, I mean, I don't know exactly what she means, but my guess is not good. Anyway, take a look at when I was in there just now, making it, I made it unlisted, then I decided, you know what, let's privatize that. We got 2,000 subscribe. Can I show you? 2,000 subscribers. Thanks to you guys. Hi, Nicole. Thanks for joining. Hi, Disney Mom. Hi, Appalachian again. I think I said hello. Jenny B. Shady Lady. Nicole, Nicole is my friend from since we were kids. This is that woman who I'm always talking about. This is her family court case where she once again makes a total asshole out of herself. Yeah, Luminessa. Deb. Pretty exciting. Take it down. Oh, it's children playing? Oh my God, why didn't she tell me that? Forget it. Of course it was children playing. Hi, Faceted Dreamer. Hi, Robin. Children playing. Jesus.
It's over $4,000 in child support and alimony that's being held that has not been released to Miss Boone. And we're asking that the court order that money be...
Hi, Classified. Thanks for joining.
...released to Mr. Boone so that he can use it to help raise their child that now he is unfortunately having to raise completely by himself, both physically and financially. Lastly, Your Honor, there is...
I agree, Deb.
There's been some motions
100%.
filed, and this was mentioned in Ms. Boone's
Thanks, Dana.
pretrial memorandum, so I'm assuming it's going to be brought up here today. Ms. Boone is alleging that Mr. Boone is unlawfully in possession of or of some personal property of hers. There is no court order that Mr. Boone is in violation of regarding that, but here's what evidence will support, and here's what Mr. Boone is willing to do, is that he does have, when he finally stopped paying for the mini storage, Your Honor, he did move items out of the mini storage to his home that are Miss Boone's personal property. He still has those items there, and if Miss Boone has any relative that wants to pick those items up, he has them packed in boxes, and he will be testifying that he has no objection to releasing those items to a family member of Miss Boone. Thank you.
We're going to have so many sexy people soon.
Before you give Ms. Boone, am I understanding that petitioner concedes there is 15 months of alimony that should have been paid? And so there is a amount that's owed, I believe it's $1,000 per month, so that would be $15,000?
Well, we're going to be arguing that he did make other payments if Mr. Boone's going to testify that he made payments to an average of $600 a month during that period of time. So
we're agreeing that he did not make $15,000 worth of direct alimony payments that were ordered pursuant to the final judgment.
That is correct.
Okay. All right, Ms. Boone, would you wish to make
as you notice, I put myself right next to her.
Opening statement?
I will do my best, Your Honor.
Christina.
I'm sorry.
Thank you.
Thanks, Sam R. Thank you for the
I said I will do
memberships.
my best. Thank you for the opportunity.
Okay. All right, you may call your first witness. Oh, I'm sorry. You said yes? I'm sorry. It's hard to understand you.
Yes, I would like to make an opening statement, please.
Okay, you may proceed.
First off, I would like to say that I am having to represent myself. I am pro se. I am not an attorney. I am not educated. I
baby.
have not gone to school, and I'm doing my best with the limited resources that I do have. And also, when the petition owner's council decided to include me on documents and whatever exhibits and evidence it is that they are proposing that they have to present to you
Right,
while in the
Tamara.
courtroom, and I am here on the telephone. I also would like to say, please, Your Honor, that the evidence that they are trying to hold against me in regards to the $600 storage unit, the $370 child support, the attorney's fees.
Hi, Danielle.
A lot of these things could have boiled down to simple communication. Would they have taken advantage of any of the mediation opportunities that were presented by the court? That a lot of these could have been resolved, including the temporary location that could have been discussed and proposed and agreed upon. Also, another opportunity could have been had in the mandatory attorneys meeting and unrepresented party meeting that we were supposed to have.
Hey, Zay Chris. Hi, Danielle. Hi, Margarita. And yeah, her voice is very melodic, Dana Lynn. It's really soothing. That's why I listen to a lot of this when I'm trying to sleep at night.
Pre-trial conference before that. And again, the defiance is not in myself, as I have been 100% transparent, cooperative, and trying to do my best with whatever it is
Hi,
I
Kevin.
can in order to prove my side and the truth, and to show my adamant intentions of being included in my son's life and trying to prove what it is that I have been legally entitled to in regards to alimony and any arrears attached to that. The defiance is coming from the petitioner and his counsel by not abiding court order payments and any other court orders in regards to the parenting plan and anything else that the court has proposed as of the official divorce. And that's including also attorney fees, which are self-inflicted when they have been truthful and ethical and providing the proper paperwork and a proper amount of time so I can actually review and correspond timely with the correct
All right, Ms.
information.
Boone, you're way off base here. I need to know, an opening statement is kind of a outline of what you intend to present at trial on the issues regarding the parenting plan proposed for the relocation and the modification of alimony and child support.
Is my motion for contempt also included at some point?
No, ma'am, I've already dealt with the motion for contempt dealing with the application. Again, I told you what the issues were that we're here on today. You may continue, but let's talk about those issues. What do you intend to present as your evidence and your position regarding the relocation proposed parenting plan and the modification of child support, the modification?
You know, this is kind of, I mean, we've all seen this many times and I think SKR had like a 9-hour video going over this, which was pure heaven on earth. And I have him to thank for many a good night's sleep. And that's a compliment, obviously, and I know you all understand. Yet, it's relatively new. I mean, considering we still watch the interrogation and notice new things, this is really like untapped somehow, right? I mean,
modification of alimony and the request for sole parental responsibility. Those are the issues that we're dealing with right now.
Yes, Your Honor.
Carolina,
I was asking
thank
in
you.
regards to the motion for contempt in regards to alimony that does not have a judgment and has been continued up to this point. That was my question for the motion for contempt.
All right, ma'am, continue with your opening statement.
has the court received my exhibits, please, Your Honor, that I sent?
We're not talking about exhibits right now. We're talking about your outline, your overview of what you intend to present to the court today.
What my case law and my exhibits that I'm hoping that you all receive.
You can continue with your opening statement.
Other than what I've actually already said, Your Honor, I'm not sure what I'm supposed to be doing, to be honest with you, so I...
Okay. Here, I'll stop for just a minute. Let me give you some guidance, okay? They are requesting that you have one visitation per month with the child and one phone call per week. What do you intend to ask this court for as far as contact with the child?
Okay, yes, please, if you don't mind, I'm going to pull that from my pre-trial statement. Thank you, Your Honor. My request that I put in my pre-trial statement were to have daily telephone calls, if I would like to have them, with my son, which he would like to have as well, personal space, and funds already added to the phone, so there's no interruption, please. Tablet credit, so he and I to be able to correspond with one another and utilize the features of the tablet to stay in communication.
Me too,
Virtual
Erin.
visits
I would have also
on the
and
kiosk.
happening.
The in-person visits, I put 1 to 2 per month with the maximum allowable time afforded by the correctional facility, please.
You're
I would
saying
like
two,
I absolutely love it, Robin. Robin said, is it just me or am I the only one enjoying that Sarah is unverified? And I watched this, when one of the times I watched this, I checked to see if she was being muted at any time, you know, unbeknownst to her. But it doesn't seem that way. And as you can see, this, by the way, was provided to me by Hear Me Out. I have his little thing here. And what amazes me about this is the balls on her. Like, this is somebody who, high futuristically fractious, and detective, who killed a man, stuffed him in a suit. First of all, spent years running around drunk as hell, embarrassing herself, being a horrible parent, terrible. I mean, left her son at school, didn't see him on Christmas, just a real piece of shit. And now she shows up with all this fancy made up language and acting as if she's as if it's so obvious that she's entitled to everything. Like, she has absolutely no sense of anything. I mean, she's that's all I got. I don't even know how to finish that sentence.
two in-person, hold up, stop. I just want to make sure I understand. You're requesting
Good luck.
2 in-person visits for the maximum time allowed?
1 to 2.
Okay. Okay, you can continue. I just wanted to make sure I understand you. Go ahead.
Yes, Your Honor, thank you. I would like to be included in all holidays, including
Okay,
schooling
Sarah.
holidays and any other time the minor child would like to include me. I would like to compel the petitioner, please, to include me in any decision-making regarding the minor child.
No shame is right, forever wonder.
To enforce communication, regular correspondence of the petitioner me in all available options, including phone calls, tablet messages, letters, third-party representatives, any manner necessary, please, that I request, so we can communicate between one another, which has been a huge problem in this entire process. And to please keep the respondent, myself, updated regarding the minor child's proposed vacations, appointments, meetings, any happenings in his life, so I can be included. to please enforce perpetual cooperation of the petitioner with myself in order to simplify, relieve, prevent ongoing and future problems for myself and the son. And please
Addie.
to stop his intentional lack of, which he has been doing so throughout this entire case. To please cooperate and
No,
just
Debs,
try to simplify things. Include me.
All right, I get the gist of that.
Hi,
They're
Crystal
also
Lachance.
requesting that the alimony of $1,000 per month be terminated.
Exactly,
What
say,
is your
Chris.
position on
And
that?
Please, if you don't mind, I'm going to pull my paper.
Oh, my paper.
All right, you're going to get a chance to present evidence. What I'm trying to find out now is just simply an overview, an opening statement, what the overview is of your position on everything, so that when I do hear the evidence, I know what I'm listening for.
Yes, Your
Okay,
Honor.
I
Thank
don't-
you for your.
Deb, I wonder if she was always like this to a degree. I just can't believe that she managed to do this much. And I guess I should, because heavy drinking can do a lot. But I don't know about. It can turn you into a total asshole, you know?
I don't need specific language. Are you contesting? Do you believe that you should still be paid $1,000 in alimony per month?
You're welcome, Debs.
I do, because the orders were active, including arrearage.
Rearage.
All right. Do you believe you should still be paid $100 per month
she
in
does.
child support?
I do not. The petitioner and myself came to that conclusion when Judge Dean was on the bench, so that should be concluded.
Right. So you agree that Mr. Boone should not be paying you child support?
Correct. Yes, Your Honor.
Because, Gail Marie, she didn't write anything in those papers. All those other assholes did.
Right. They made a statement that there is approximately $4,000 that is sitting
I will
in
be,
the
shady
clerk
lady.
of
Go feed them.
courts with regard to child support. They're asking that that be returned to Mr. Boone so that he can use it to care for the child. Do you agree with that?
I do, only if he decides to include me, please, on some of the things that I would like to have my son to have also, and things that he had made mention to me that he would like to have
Exactly,
in order
Addie.
to become more of an adult and his growth in his teenage years.
All right. All right, so Ms. Boone, what's going to happen now is because the petitioner is the one who's filed the petition to relocate and the petition for modification, he has the burden of proof, and so he goes first. So I'm going to allow him to present his evidence. He's going to be able to call witnesses and offer documents to the court. If he calls a witness to testify, you will have an opportunity to ask cross-examination questions, okay? Then once he is done with all of his witnesses and all of his evidence, then the court will turn to you and I will hear any testimony, any witnesses you want to call, including yourself. And if you call a witness or if you testify, then his attorney will be able to ask you cross-examination questions, okay?
Yes, Your Honor.
And I have confirmed that we did receive in the mail some documents that were your exhibits. When it becomes your time to present your case, we'll pull those exhibits and then you'll be responsible for moving those into evidence, whatever you want to move into evidence. The attorney will have an opportunity to either object or to say he does not object to the court considering any specific pieces of evidence, okay? But you will get an opportunity.
Yes, Your Honor. Thank you.
All right, so we'll go ahead and we'll have petitioner call your first witness.
Thank you, Your Honor. I'll call Mr. Boone.
Give me just a minute to set up.
This is for the relocation, please.
I'm sorry, say that again?
What is the first document that we are attempting?
It's not a document. Counsel has called Mr. Boone to testify as a witness. And I don't, can you, like, Mr. Boone, can you just say your name from sitting there?
Brian Boone?
Can you hear Mr. Boone?
Yes.
I was actually wondering, Your Honor, if it's okay if he goes up there to the witness stand. Is that okay? Or is that going to be too complicated?
No, I don't think it will be, and it's probably wired so that it's probably, you can hear him better from there. So I'm going to go ahead and have you go ahead and move to the witness stand.
Was that Brian? Was
Can I
that
remind
Brian
you,
sitting
Mr.
down?
Boone,
That
you
was
are
not me.
under oath.
Let's.
Yes, Your
let me
Honor.
do that again. Talk about private sound.
And I
Sheesh.
have confirmed that we did receive in the mail some documents that were your exhibits. When it becomes your time to present your case, we'll pull those exhibits, and then you'll be responsible for moving those into evidence, whatever you want to move into evidence. The attorney will have an opportunity to either object or to say he does not object to the court considering any specific pieces of evidence, okay? But you will get an opportunity.
Yes, Your Honor, thank you.
All right, so we'll go ahead and we'll have petitioner call your first witness.
Thank you, Your Honor. I'll call Mr. Boone.
Give me just a minute to set up.
This is for the relocation, please.
I'm sorry, say that again?
What is the first document that we are attempting?
I think so, Disney.
It's not a
Mom. I'm
document.
Not sure. Robin might know.
Counsel has called Mr. Boone to testify as a
Because
witness.
Karen D.
And I don't.
She's not going to say
can you-
sorry.
like, Mr. Boone, can you just say your name from sitting there?
Brian Boone?
Can you hear Mr. Boone?
Yes.
I was actually wondering, Your Honor, if it's okay if he goes up there to the witness stand. Is that okay? Or is that going to be too complicated?
No, I don't think it will be, and it's probably wired so that it's probably, you can hear him better from there. So I'm going to go ahead and have you go ahead and move to the witness stand.
All right, let's listen to this.
All right, and I remind you,
Feels
Mr.
pain.
Boone, you are under oath.
Yes, Your Honor.
Okay.
Okay, Mr. Boone, good afternoon.
Afternoon.
So, Ms. Boone has consented to the relocation, so we're going to skip a lot of
IVC.
questions about how your son's doing there, and we can fast track some things a little
Hi,
bit.
Joette.
I wanted to
Yes.
start off with going through with you the your proposed parenting plan, and that has been marked for identification purposes as Petitioner's Exhibit G. Now, Your Honor, these were all mailed to Ms. Boone, and we have I have a copy of the tracking receipt. I just want to make sure Ms. Boone has these. So if you, I don't know if
Ms. Boone, did you receive petitioner's exhibits?
For the notice of filing proposed amended parenting plan?
yeah,
Yes.
that's one of them. Okay. So I guess, does she have any objection for me submitting this as a exhibit?
All right, Ms. Boone, do you have a legal objection to the court considering that proposed parenting plan?
No, Your Honor.
I understand that you do not agree with it, but do you have any objection to the court considering it?
No, Your Honor.
All right, hearing no objection, I'll receive into evidence what was pre-marked as petitioner's G is petitioner's exhibit number 1.
Right. I thought this is not live, but we are, in case that was the question. Because I had started a live before and then I had to stop it. And then I had to privatize it because we could hear sounds like children playing and me breathing. And now we're here. Oh, shit. God punished me, as usual.
Mr. Boone, I'm going to give you a copy of what I just handed to the court here.
Okay.
Okay, sir, so we'll skip right to the meat of what we're proposing here, and that would be located on bait stamp page 082, which you'll see the bait stamps on the top right-hand corner of the documents. You see that there? Mm-hmm. Okay.
Oh, Carolina.
In this proposal that you submitted to the court, you're asking that the father have 100% sole parental responsibility and shall make all major decisions affecting the children's.
Hi, Claire, and welcome, the rain. Good to see you. Both?
Or the child's welfare, it says children's, but you only have one child with Miss Boone, is that correct? Okay.
Yes.
And how old is your son, by the way? So I want to ask you a few questions regarding your request for sole parental responsibility. First off, since February of 2020, has Miss Boone had any overnight contact with your son?
No.
Okay. Has she been involved in any major decision related to your son since February of 2020?
No.
Okay. Practically speaking, if there was a major decision that needed to be decided upon, how would you go about having, if Miss Boone did have shared parental responsibility and was had equal power to make decisions related to your son, practically speaking, how would you even do that if she's in federal or in prison?
No idea. I have no way of contacting her. It'd be sitting around and
So
waiting for
stupid.
her to call or something at some point.
Okay. And has Miss Boone had telephonic contact with your son since she was incarcerated?
Yes.
Okay. Does she have frequent telephone communication with your son?
Off and on. There are weeks when there are tons of phone calls and then weeks where there's none. It's just kind of, I don't know.
And when she is talking to your son, how does that go? How does it go? Is it good? Is it?
Coin flip. Sometimes he's very upset afterwards at things she had said to him, and sometimes she's in a great mood and they have a great conversation. It's very, you never know what's going to happen.
And when she's talking to your son, does she support your decisions, or is she a contrarian? Can you tell me exactly how she interacts with
Mainly
your son?
Mainly contrarian, from what I understand from. I can't hear too much of them because she forces him to make sure he is nowhere near me when he talks on the phone with her.
Okay. Can you give me a specific example of where, after she's had a phone conversation with him, you've had difficulty with him?
Well, generally it's with buying things he wants, which, I mean, kids want all kinds of things. That's what birthdays and Christmas and stuff like that's for. Everything's not instant gratification. And he'll tell her about these things, and her response is, well, just Dad should get it for you. So,
Okay. Given the decisions that she made that led to her arrest and eventual conviction for second-degree murder, do you have any concerns about her decision-making ability?
oh, of course.
Okay. What are some of those decisions, or some of those issues, the specific issues you have with her decision-making ability?
I don't think she makes good decisions, even without the alcohol. I think she has some problems that need to be worked on.
Okay. And when she was not incarcerated, prior to incarceration, what was the time-sharing schedule on paper that you two had?
It was a 50-50. One of us was Monday, Tuesday. The other one was supposed to be Wednesday, Thursday, and then we alternated Friday through Sunday.
Okay. And prior to her incarceration, was she exercising all of the overnights that she?
No, it was about 30%, and it was sporadic as to kind of when she felt like it. Not even on days she was supposed to. She wouldn't have him for like a week and a half, and then she'd be like, I want to have him tonight and tomorrow night. And I'd be like, well, those are my days. And she's like, well, I haven't seen him in over a week. And that's kind of how things would go, because so it'd just be like that. And then occasionally I'd be called over to pick him up at night because she had started drinking or wanted to drink and didn't want to take him to school in the morning or what have you. So, yeah, it was a lot of that.
Okay. And during that time period before her incarceration, was she actively involved in the decision-making process with your son? Was she?
Not really. She was kind of in her own little world at that time.
And if there is a decision that needs to be, a major decision that's needed to be made regarding your son that involves some type of monetary commitment, does Miss Boone have any ability to contribute monetarily to that commitment?
No.
Okay. So is it possible that if she were to be able to have equal say in decision-making around your child, that whatever she decides, you're going to be 100% responsible financially for that decision? Is that correct?
Correct.
Is that one of the other reasons why you're asking for sole parental responsibility, since you're the only parent that can financially execute any decision that needs to be made?
Yeah.
Okay. And do you see any problems with the fact that if there was a joint decision that needed to be made regarding a major decision of your son, do you see any problems with Ms. Boone having input on that decision if she is not going to be financially responsible for it?
I mean, I don't mind her giving some input on it.
Okay.
No. I just don't want her to have any kind of legal availability to make a decision.
Okay. Now, is she informed of what's going on with your son?
I mean, when she talks, I guess he tells her. Once again, I never hear the phone calls, so I don't know.
Okay. But does she have the ability? She's had phone calls where she can ask him about what's going on in his life.
Course.
Is that right?
Mm-hmm.
Okay. And you're not looking to restrict her ability to be able to contact her son and talk to her son about what's going on in his life? Is that correct?
No, I mean
within reason, I should say.
The amount of calls,
Okay.
yes, but no.
I have a question for all of you, and Robin might know if she's still here, which I hope she is. Do you think that, because to me this seems very lenient, like this is a very, the offers that, the guidelines that Brian sets forth to me are very generous, maybe too generous. Like, I just feel like personally once a month is a lot, but would his lawyer have told him, right? Like, you can't, the judge can't, well, force your son to visit her in prison. And, you know, do you think that his lawyer told him it's better to come off as reasonable and generous in most ways, certainly when it comes to her parental rights or whatever, access to her son, because there are certain things the judge just won't do? You know what I mean?
Okay. And let's get into that. Your proposal is that Miss Boone have one weekly phone call with your son. Is that right?
Yeah.
Okay. Now, first of all, are these phone calls free?
No.
Okay. So how much do they cost every time Miss Boone wants to have a phone call with your son?
It's about $5 for a 30-minute call.
Okay. And in the last month, do you know how much you've spent on those phone calls?
Well, I mean, I said like last week, she didn't even call him last week, so that was like a zero. But the week before that, I mean, she called a bunch. She probably had 6 or 7 calls, so that's like 35. She called last night, so that's 40, and then maybe $50, $60 in the last month.
Okay. When she does try to contact your son, do you try to accommodate her most times?
Oh, of course.
Have there been times where you weren't able to accommodate her?
Well, I mean, yeah, his phone's dead, or he
Right.
didn't have it with him, or it was on silent, or any number of things.
Okay. Now, regarding actually in-person visits, has there been any in-person visits at the current facility she's
Yeah.
located in? Okay. When she was in the John Young facility, was there in-person visits that were?
They're not allowed.
They're not allowed. Okay.
Yes.
Hell to the
It's
wood
not even a
range.
possible. well, you can go there, but you're in a building across the street doing it through a computer. There's no possible way to physically see somebody there.
Okay. So this new facility is the first time that there's a possibility to be in the same room as her
Yes.
son? Okay. And how far is that facility from where you live in Gainesville?
I think it's like an hour 20, something like that.
Okay, so a round trip just to visit mom is going to be approximately 3 hours?
Probably, yeah.
Okay. And when are these visits scheduled? Do you know?
Well, if we were to do one, it would be on a weekend. I don't know if they do them on the week or not, so.
Okay. So if you were to execute one of these visits on a weekend day, that's pretty much going to take, is it going to pretty much take the entire day?
It would be a day, yeah.
Okay. And are you going to be the one that has to drive him there? There's no other family members that Miss Boone has or any that could take?
Well, I mean, I have family members who could, but.
But no one on Miss
No,
Boone's side?
it would be me doing it.
Okay, so it'd be either you or your family members that would have to
Correct.
take him? Okay. And so why do you believe that one visit per month is appropriate?
I think that's plenty enough. I mean, I wouldn't want that necessarily like set in stone. I would like it to be a little more flexible because, I mean, there's quite possibly, going to be situations where, it's only on weekends. So you've got like 4 weekends out of the whole month to get it done. And if he's got extracurricular things, we have season tickets for football games at UF. We go to games all the time. We have basketball season tickets. So there are lots of things we're doing. So, it's entirely possible we'll have a month where all 4 weekends are just taken up that month.
Would you be willing to commit to 12 visits a year, which would average out to be at least once a month?
Yeah, something like that would probably work.
Okay. And tell me, where does your son currently go?
High school.
Okay, and is that a magnet program or is that a regular school? What is that?
Well, yeah, it's a biotech magnet program he got accepted into.
Okay, so explain to me, what are the commitments of a student that gets accepted into a biotech magnet?
Well, it's a lot more heavy math, science, stuff like that. There's a specific biotech class he takes every year over his 4 in high school for it. Also, the school itself is over 11 miles away from me, so, and there's no busing, so I get to drive him to and from school every day.
Okay, and does he usually have a lot of homework on the weekends?
He does, yeah. He'll have homework, yeah.
All right. All right, let's get into some of the other issues, the monetary issues here. So I stated in my opening statement, but I'm going to ask you here while you're on the stand, is it true that when Miss Boone was incarcerated in February of 2020, you stopped paying the exact $1,000 a month alimony amount that was in the final judgment?
Yes, I would, through Zillow, through my bank, I would send her the $1,000, and with her incarcerated, she couldn't even use her checking account, so there wasn't really a reason to do that. So, at the very beginning, her idea was she kind of kept notes of everything I was buying for her to kind of tally up how much I was doing, and then we'd figure it out at the end, and then 1 year turned to 2 years and to 3 years.
Okay. And eventually you stopped making any payments to her?
Yes.
Okay. So in February of 2020, do you know approximately how much per month for that period of time that you were continuing to make her payments, how much money you were giving her that was not things you were paying for her for, but actually direct money to her?
Probably say about $600 a month.
Okay. And when did that stop? When did you stop doing that?
Probably close to 3 years into it, something like that. It was, after like her, first, coin-appointed lawyer, quit on the case is kind of when I gave up because I just felt she was kind of delaying things at the time and we were never going to get to a trial.
Okay. Were you still paying her some money after you filed your petition to modify in April of 2022?
Yes, I think I was still.
You're still paying her some money?
I believe so.
And in my opening statement, I mentioned,
I know I was still doing the storage container at the very least.
okay, that's why I wanted to ask you
there was
about.
other stuff I was doing also.
Okay, so how much were you paying for that storage container?
Well, locker, sorry. I think it was like $240 a month, something like
And
that.
was that a mini storage facility?
Yeah, it was like what was it, probably 10 by 10, 12 by 12, something like that.
Okay. And when Ms. Boone was first arrested, did you help move those things into that mini storage facility?
Yeah, I did. There was nobody else in her life to help her sell. It was me.
Okay, so you moved her stuff in there, and then you paid the monthly fee
Yeah,
for
I
the
had
mini
to
storage.
rent a U-Haul and physically move everything, and yeah.
Okay. And when did you stop paying that? Do you remember?
I think it was a while after I moved.
Okay. And when you were buying things for her, what were the
See you soon, Sophie. Thanks for joining.
what were the type of things you were buying for her?
Hot meals, gift baskets,
Wings.
just money in general on her account, whatever it is, thing in jail, phone calls, excuse me, stuff like that. There was probably other things. I mean, presents she'd want to get, she obviously couldn't buy them, so I would buy them, and yeah.
So you'd buy presents with your own money and then make them presents coming from her?
Yeah.
Lucas?
Every Christmas and birthday, and yeah. Okay, she'd have a list of presents she would want me to buy him, and I would buy them and wrap them up for him from her, so.
Okay. And you said you eventually stopped doing it because she got a new attorney and you just felt like the case was dragging on. Can you expound on that? What was your frustration there?
Because I didn't see an end in sight. I wanted, because we had already gotten this thing going. The judge wanted to wait for the trial to end before we could do anything with all of this. And it seemed as though she was just dragging things on almost on purpose, just so this wouldn't happen.
Okay. Now, during this time period, you had to hire private attorneys, is that right?
Correct.
Because she is trifling, like all these bitches we see.
And I'm not your first attorney, is that correct?
No. She stopped practicing and recommended me use.
Okay. And do you know how much you paid to your first attorney to file the initial modification proceeding?
Well, she didn't fit. You filed the initial one, I think. You didn't?
No.
Did she do it when you?
Well, actually, maybe.
Hold up.
All right, we can't have a conversation like this.
I'm sorry.
Let me
Sorry. No, I believe you did.
Let me rephrase the question. Let me rephrase the question. How much did you, the first attorney that you hired to pursue the modification case, how much did you pay her? Do you remember?
I do not remember. She did write up an entire thing to change it, because I was going to be submitting that.
Sir, answer the question. How much did you pay the attorney?
I don't know. I'm sorry.
Next
Okay.
question.
I'm sorry.
Okay. And during the time period that that Ms. Boone was incarcerated, you were still giving her some funds, paying for her mini storage. Were you also paying for 100% of the expenses of?
Yes.
Okay. And was there any time since her incarceration that Ms. Boone gave you any money to help out with?
No.
Did she direct any family members to give you any money to help out with?
Oh, men are trifling too. I mean, not every single one of them, of course, but you know, I don't know why trifling bitches just rolls off the tongue. You know what I mean?
Okay. And tell me a little bit about. Well, let me strike that. Okay. So let's go back to attorney's fees. Do you know how much approximately you have spent in attorney's fees for my representation?
I think around 14,000.
Okay. This time, Your Honor, I would like to submit what has been marked for identification purposes as Petitioner's Exhibit F. It is a summary of Mr. Boone's attorney's fees he's paid to our firm.
You offering that into evidence?
Yes, I just want to see if Ms. Boone has any objection.
Ms. Boone, do you have any objections to what was pre-marked as Petitioner's Exhibit F?
No, Your Honor.
All right, hearing no objection, I receive what was pre-marked as F as Petitioner's Exhibit number 2.
Sir, I'm going to hand you a copy of that exhibit.
Thank you.
Okay, sir. If you look at this exhibit, if you just look at, I'm going to direct you to Bait Stamp page 49. It's the first page. What's the date there on the top left-hand corner of the last entry up there at the top?
7/29.
2025? Okay. And if you go back to the last page, which is Bait Stamp page 79, what is the first entry on those billing records?
3/21/22.
Okay. So it looks like these billing records encompass approximately 3 years and 4 months worth of activity. Is that correct? Okay. And we're now in August. We're now August 25th, 2025, and we're in the middle of this trial. So the $12,050 that's on this summary here, has that increased?
Yes.
Okay. And is that where you're getting the approximate $14,000? Okay. Okay. Now, Ms. Boone indicated in her opening statement that if people would have asked her, she would have been agreeable to some of the relief that we're seeking, basically, in essence, is what she said. I want to ask you, in all the calls that she made to your son, did she ever talk to you about settling this case?
In a way that would benefit her, yes.
Okay. Did she ever tell you that she would just agree to the relocation?
No.
Did she ever tell you that she would, well, I want to ask you this. She mentioned that you two had a conversation about the waiving of the child support. Did that conversation happen?
Not that I remember.
Okay. So there's never a time where she told you you don't need to worry about the child support?
No. I don't remember that happening.
Okay. In any conversations that you had with Ms. Boone, did she ever tell you that specifically that she didn't want you to move to, she objected to the relocation?
Yes.
Okay. Now, Your Honor, there was a stipulation regarding the money from the clerk of court. You don't need me. Do you need me to ask any questions on that? Or has that been stipulated by Ms. Boone?
Probably do, because I think her response was that she objected to a condition upon something.
Okay. All right, sir. So I mentioned in my opening statement that there's some funds that you have tied up with the clerk of court right now. Is that correct?
Mm-hmm.
Do you know approximately how much that is?
I think it's like 4,000.
Okay, and
I could be wrong.
what does that money encompass?
Child support payments.
Okay. And are you asking as part of the resolution here today that that money be refunded to you?
Yes, please.
Okay. Now, let's also talk a little bit about your income. Are you currently employed?
Yeah.
Okay. When was the last time that you were employed?
Back a little while. I've had some online things off and on at times.
Okay. For purpose, when was the last time you were employed full-time?
Probably 2021, 22, something like that.
And you know,
I'm going to stop you for just a minute.
sure.
If I seem to remember correctly, there was a stipulation with him earning $60,000, and I bring it up only because there was a motion to compel, and I denied that motion to compel based on your representation that you're going to stipulate to income of $60,000.
I was just going to get him to acknowledge that he's stipulating to that. That was my next question. Yeah. So I just want to make sure that was on the record, but or at least clear to the court here today through testimony. So, sir, regardless of last time you were employed full-time was 2021. Today, for purposes of calculating what the support should be today and moving backwards, are you willing to impute 60?
Malbec or Zinfandel? I'm not sure. Not sweet Zinfandel. Red, just red wine.
$1,000 of income to
Yes.
yourself. Okay. All right.
How about you?
Now, all the phone calls that Miss Boone has had with your son, have you paid 100% of all those calls?
Yes.
Okay. Has there ever been any family member or anyone else in Miss Boone's family that's given you any financial assistance towards?
No.
All right. Now, Miss Boone indicated in her pretrial memorandum and in other places that she's alleging that you have possession of some of her belongings.
Mm-hmm.
Are you aware of that?
Yes.
Okay. Do you have possession of some of her belongings?
Yeah, anything that had any kind of value I had gotten out of the storage unit, so.
Okay. And you took it out of the storage unit when you stopped paying for the storage unit, is that right?
Yes.
Okay. And where did you relocate those items to?
To my house in Winter Park, and then they came with me to.
Okay. And do you still have those items?
Yes.
If Miss Boone were to have a family member come by or a friend come by asking for those items, would you release those items to that individual? Okay. Sir, despite Miss Boone being where she is and having done what she did, are you still committed to making sure that your son has a relationship with her?
As long as he wants one, yes.
Okay. While he's still a minor and he doesn't get to make decisions for himself, are you?
Yes.
Okay. Okay. I have no further questions, Your Honor.
Give me just a minute. Right, Ms. Boone, do you have any questions for Mr. Boone?
Yes, Your Honor.
All right, you may.
Bossy too, but she knows for a fact, and everyone knows for a fact, that Brian took all of her valuable heirlooms and.
Inquire.
Your Honor, is there a particular order I'm supposed to follow?
I'm sorry, I can't understand you.
Is there a particular order I'm supposed to follow in regards to items or topics?
Ordinarily,
Here she comes.
I will. You just need to. You do not have to stay in any particular order. You just need to ask him questions regarding anything he just testified about. But to save
Okay.
time, if we have additional stuff, are you okay with her going out instead of
Oh, yes.
calling him?
Yeah.
All right. So no order.
No, the answer to the question, Tanika, is, and you know as well as I do, she is not grateful for anything ever. She will thank bomb people when in the moment, but no good deed goes unpunished with Sarah Boone. It is absolutely amazing, and particularly because she does not care about her son. So she just. I mean, can you imagine all of the people who are in prison worried about their children and where they are and who's taking care of them? And Sarah Boone has been getting money from this man. He is a wonderful parent. She doesn't care. She wants to put him in prison too. No thought of what that would do to her child. Does not care at all. It's just so disgusting.
And you can ask him any questions based on the testimony he just gave or any of the issues that you're raising or your positions in the case. Okay.
Thank you. Brian. When have you ever included me since my incarceration of February 2020 in any major decisions at all regarding our son?
I mean, there haven't really been any huge decisions.
COVID wasn't a huge decision.
Well, no, we did, and you told me that you did not want him to get vaccinated, which scared the crap out of me that you thought that.
Relocation?
What's that?
Relocation.
Yes,
Did you ever talk to me about COVID? Did you ever talk to me about relocation? Have you ever included me in any major decision-making question?
Well, yes, and I disagreed with you.
When was the last time you answered a phone call of mine?
Why?
Yeah, Deb. Deb says it would be great to see if she had a camera on to see how uncomfortable she is, and I want her camera on to see how fat she got. To be honest, if I'm just being totally honest, and also to see her, watch her just be an asshole. But
Kyle.
hey, tell the truth.
Why do you not answer my phone calls when I attempt to communicate with you?
Well,
Because
I'd
I
like
don't
to answer that
care to
because
talk.
he might be cleaning his townhome or looking for jobs. You should know better than anyone, Sarah, why he doesn't answer your fucking phone calls.
Talk to you.
So in regards to our son, you do not want to communicate with me.
If there is a conversation you want to have about, you're welcome to have it with me. That's not what you call for.
What else is it that I call for?
To yell at me about some random thing or tell me I need to buy things for.
You do realize, Brian Calloway, that you are under oath.
I do.
When was the last time you ever answered a tablet message?
Right, Addie.
I've never answered a tablet message.
Including from Orange County 5 years ago.
Correct. Mm-hmm.
Why is that?
Because I didn't want to.
So you do not want to speak to me on the phone, and you do not want to answer tablet messages.
Yes.
How else do you propose you and I communicate being the parents of our son?
I'm not sure what it is that you wanted to communicate about him.
Major decisions are one. Also,
for instance,
when have you ever responded to any of my letters that I have written to you from no response or answer of a phone call?
what, like in the mail letters?
A handwritten letter, yes, that I have mailed to you.
I don't think you've done that in like 4 years.
You just told me 2 weeks ago that you received mine in regards to the visitation applications that I sent to you.
Well, yes, that wasn't a letter to me. That was an envelope with some applications in it.
In the parenting plan, it says that you are not to use the child as a ploy or a mode of communication. How else am I supposed to communicate with you if not through our son, through a letter, a tablet, or a telephone call?
Yeah, I read all your tablet messages.
Oh, I read them.
If you've got something you need to talk to me about it and you put it in the message, I will see it and I will answer your call. Or maybe even write back, but I've never seen that.
Hi, Sandy Rodriguez. I tried to put that in the chat, but I don't think it went through.
You just said that you do not answer phone calls because you do not want to. You just
Yes,
said you do not have these text messages because you do not want to. You do not respond to letters. Therefore, I have to ask you, regarding our son. You are putting our son in that predicament. Is that correct?
Now, if you have something legitimate you want to talk to me about, then you let me know, and I will talk to you about it.
How would you know if it was legitimate or not? You don't answer. I have nothing ever to speak
Once
to you
again,
about in regards to anything other than our
Hold on.
son.
Wait till the question's over. All right, now you may answer.
Once again, you can write me a tablet message explaining the question, and then I can answer. Or two, just when you're on the phone with Luke, have him say, hey, mom's going to call you out, blah, blah, and then you can call me about it.
Blah blah.
That's not making him communicate between us.
Why you can't just communicate as an adult and a parent do not have to include our son
All right,
in
next
this.
ask a question, Ms. Boone. Not argument, ask a specific question.
Why do you allow, why was your statement made that our son is upset after speaking to me on the phone? Do you know specifically why? Because you asked me or him?
Because he tells me. I can see him.
I'm asking you if he explained to you why he was upset.
Yes.
And why is that?
Can I
Can I curse?
I mean, any number of different reasons. The way you talked to him, what you said to him, how you made him feel. I mean, the plethora of emotions that you corrupted.
Is it because you allowed him to curse on the phone?
That I allowed him to what?
The majority of the time I will tell you this, which you are unaware of because
You're
you
not
do not
telling anybody anything, ma'am. You're asking a specific question. Ask your question.
Yes, Your Honor. Do you understand the majority of him being in quotes upset is because you withhold him coming to see me? And he's had to wait over 9 months now that he has the opportunity to, and you continuously lie to him and me about, and the court.
Sandy, this is a no apology zone. You may speak freely, especially if you're cursing. It's encouraged here.
Filling out the application.
Okay. Not at all what he tells me. You
too,
specifically, the way you talk to him is what upsets him. And honestly, before yesterday, after you got done talking to him, he told me that he would prefer him being able to make the decision of when he wants to talk to you.
Right, Tanika. The son's cursing on the phone makes him sad. The fact that she just first of all, what is it? 1952? Where in the world is it still so frowned upon? I mean, they're not in a church here, they're in a courtroom. To let your child curse. And why would that be upsetting him? She just has to get that in as what's wrong with her? God.
Yes, we spoke about that yesterday, and what he said to you was,
Right. So
Did
I'm
not
going
know
to
all
object
of
at this point that the child here
All right.
is happening.
I'm going to sustain the objection. Move on to a different topic.
Hi, Michelle DeMatteis. Good to see you.
so in regards to telephonic communication,
Telephonic.
which is regular and has been, I wanted to find out if you understood that I know about his girlfriends, about his laughing and joking.
Not
and his
gonna,
great-
ma'am, we're going to stay on topic with regard to the issues here, which are the proposed parenting plan regarding the sole responsibility, the modification of child support, and the modification of alimony. Your question on those issues is?
Yes, Your Honor. The sole responsibility has not changed since day one of me being incarcerated. He's never asked me.
I'm
to be
not
a part of
asking
any-
you for your position, Ms. Boone. I'm asking you, do you have any additional questions for Mr. Boone on those topics?
Have I ever purchased a gift or something for?
With your own money?
How's
Have
that,
I
baby?
purchased any items for our son?
Well, I purchased them.
Your Honor, I need,
Hold up, stop.
I need some scope of what time period she's talking about.
All right, I'm
What
going to
is it?
sustain the objection, re-ask your question, and you need to put
I need some scope on what this fucking lunatic is trying to get to here, and when she's talking about, and
a specific time period in your question.
Within the last month,
right, Beaches.
what have I purchased for our son?
You had somebody third party else, not you, buy him a record for his vinyl player.
Have I purchased previous items for him?
You have had a third party, not your money, not you, purchase some things for him. Yes.
What family members do I have helped pay?
Excuse me?
I'm sorry?
What'd you say?
My family members. Who is it that I can have help pay?
Philip's the only person.
Why is that?
Yeah, Jackie. that was
Because
good.
your other brother's not really capable of doing anything, and your mom and dad are dead, and you don't get along with any of your other relatives.
Are my grandmother and grandfather deceased?
Well, I mean, you're almost 50 years old. Most people, their grandparents are
You old
deceased at that
hag.
point.
All right, Ms. Boone, what's the relevance of these questions?
Because they're trying to make me seem that myself and no one in my family is contributing to my son. And it's difficult when my family is deceased and my younger brother is in the military on his 9th deployment in Israel. So
right, ask your
whatever
next
it is
question.
I do.
Ask your next question.
May I please put in an exhibit?
Any objection to her putting it?
I haven't, I'd like to see it, and what she's specifically talking about.
Which exhibit, Ms. Boone?
The exhibit, please, is number 37 on my exhibit list per the uniform order, the GPL communication current pricing.
Give us a minute.
May I approach the
I'm
clerk,
sorry,
Your Honor?
number 36.
Just a minute.
Me too.
I have no
Rosie, too.
objection.
All right, Ms. Boone, council has no objection to your exhibit, so I'm going to receive what was pre-marked as number 36 as respondent's exhibit number 1.
Yes, Your Honor, that is to show, please, that it's 13 cents per minute for me to speak to my son on the phone. And also the fact that we have
Hold up, stop. Slow down for just 1 minute. Do you want Mr. Boone to see that document? Are you going to ask him a question about the document?
Yes.
All right, just give us 1 minute. Mr. Boone has taken a look at the document. No, he's going to keep it.
Dandy says the great thing about when you're in your after 40 or whatever. Great thing about starting a new job is all your grandparents are alive again. I had a contractor in an apartment I had a few years ago, and in my marital home, as Sarah would say. And he was a little touch and go. He was fine, but I mean, he was a man. I would say he's probably 60, 55 maybe. At the very youngest, he was 50. And he called me one morning. Well, sometimes he would call me drunk at night. Not a lot. But one morning, and I mean not to talk about, about what was going on in the apartment. One morning he called me and he told me that his grandmother died. And I, of course, was like, I'm sorry for your loss. And I hung up because what am I going to do and who cares? I mean, not about that, but. And I was with my friend Catherine and I said to her, now his grandmother died. Not now. I mean, I'm sure she did die, but 20 years ago, But all of a sudden, I mean, that's what you come up with? Just say you can't show up. Like,
All right. Do you have a question for him about the document?
When you originally signed up for this account in order to utilize the phone option, were you aware of the 13 cents per minute?
Yes, I have to pay for all the phone calls.
So you accepted the fact that it was 13 cents per minute?
You don't have a choice. That's the only way to have phone calls in the
It's a
jail.
simple yes or no. For most of my questions, it's just a simple yes or no.
All right, ma'am, what's the point of this questioning?
yeah.
Because he's making it seem that it's a very extensive phone call for me to speak to my son, and it's just 13 cents a minute, and we don't utilize the full 30 minutes each time. So by him setting up this phone account for the 13 cents per minute and free phone
All
calls.
right, the court has taken notes that it costs 13 cents a minute based on exhibit number 1. Your next question.
Okay. This is in regard to the exercising
Thank you,
of
Michelle.
overnight,
Thank you.
where he stated,
I have to stop talking when the video is on. Thank you, Michelle. That's very nice. And that's really all I care about is my looks. So thank you. And also, Sarah does this at one point in this hearing. She actually says like this very like, yes, Your Honor, like such an obvious, obnoxious kind of. I don't know what play she thinks she's acting in, but she's always in it. And she's been doing this please thing since, forever. She did it in the interrogation. She was like, and again, if you don't mind, please.
that it was 30% about for my average. Can you please explain to the court my conversations on more than one occasion of why I could not have 100% or 50% of my time?
So I'm going to object. That's self-serving hearsay, what she said to him.
All right. I am going to sustain the objection. Next question.
Did I ever explain to you the safety risk and danger of having my son come over on particular days that it was mine?
Okay, Bonnie Gunn. Bonnie Gunn's grandfather died last year and she's 58. Well, I'm sorry for your loss. For real. But my contractor's grandparents were no longer alive.
Not
Know that.
really? I mean, kind of, yeah, I guess. I don't know, most of the time when you had me come over there and pick him up and was supposed to stay over at like 10, 11 o'clock at night, there was nothing going wrong. It was just the two of you drinking and having fun, and I guess didn't want him there anymore.
Yeah, her audacity.
Brian.
Next question, ma'am.
Time when you had me come over there and pick him up and was supposed to stay over at like 10, 11 o'clock at night, there was nothing going wrong. It was just the two of you drinking and having fun, and I guess didn't want him there anymore.
Brian.
Next question, ma'am.
Did ever tell you that he liked being more at your house because of everything that you had and everything that I didn't have?
Hi,
I'm
Zach.
going to object, as that's a question based on hearsay.
Sustained. Next question.
Did you have more entertainment than I
Hi, Olive Oil.
did?
Really, in all honesty, no. I mean, you had a computer, I had a computer, you have a TV, I have a TV. You've got open spaces to play in, I had open spaces to play in. You had a pool, I had a pool. I mean, yes, my house was a bit bigger than your apartment, but I mean, it's kind of the same things.
Do you understand what my criminal case was about?
Oh, yeah.
This, I love this part. Just saying.
Do you understand the domestic violence part of it?
Hi, Olive Oil
No.
again.
Well, yes, just not from the side you think.
Did you watch my trial?
Yes.
Did you see the pictures?
And I saw the videos.
Boom.
In regards to the children's rights, I would like to ask, please, number 6, where it says not
Good
to hear
question,
parents
Tamika.
speak ill of each other, nor to hear about the difficulties of the other parent. Have you ever called me murderer
No,
in front of our son?
no,
Have you ever called me killer in front of our son?
no.
You do realize you are under oath.
Oh, fuck you.
Yes, there is a difference between calling me a murderer and saying you're being tried for murdering someone. Those are not the same thing.
Have you ever called me a murderer in front of our son?
Asked and answered. Move on. Next question.
Have you ever made an attempt?
Forever wanted to know how is she not embarrassed. She's never embarrassed. She was born without the get embarrassed gene. We are all here to be embarrassed for her because someone has to, and everyone is.
To find out contact information for me while I am located here.
To say that again?
Have you ever attempted to find out contact information from me while I am located at BOC?
What contact information?
Should there be an emergency,
Ugh.
have you ever tried to find out how to contact me?
I would call the jail and ask them. Or the prison,
So you do
whichever
have
one.
an option contacting me.
What's that?
So you do have a way of contacting me.
I have no idea. I don't know what the rules are. I don't know if I could get in contact with you. Maybe they could let you know. I don't know.
Have you ever made an attempt? Have you ever asked me? Have you
And
ever
what's
responded?
the relevance to the issues that we're here on today, which is the relocation proposed parenting plan
I don't know.
and the
Addie.
request to modify either actually, child support's not an issue, but to modify alimony?
This is where I'm unclear, Your Honor. I'm not sure what exactly I'm supposed to be doing. Is this in regards to the parenting plan for the relocation?
I've explained to you more than one time the issues that the court is considering today. You need to be asking questions.
Right, friggin' Pope. Oh, my son's really sick. I better call that degenerate who's in prison for life. The thing is that Sarah doesn't understand anything. She doesn't, this is my opinion, of course, have real feelings, and she has nothing but audacity and a sense of entitlement. So she only knows that she's this boy's mother, and that as the mother, she feels she has all of the rights, and it should have nothing to do with the fact that she stuffed a man into a suitcase, filmed him dying, and her mocking him. And now that she's been sentenced to life, she thinks about it like, well, a mother's supposed to know, a parent is supposed to know in an emergency situation if something's happening to their child. It doesn't matter where they are and what the circumstances are, but it does. And you had the chance when you were out in the wild to be a mother, and you weren't ever really.
Regarding those issues, I will say them one final time. The issues are the petitioner's proposed parenting plan that was filed
Me
in
too,
relation
Detective.
to the petition for relocation, and then the request to stop alimony. And there's also a request for attorney fees. Those are the issues the court is considering. Those are the issues that you should be asking questions about.
I had no idea that the relocation parenting plan was even an issue, considering the fact it's been agreed upon.
I'm not sure why you have no idea when I've said it. I think this is the 5th time that I've said it.
Forgive me, Your Honor.
I also think it's funny that all of the judges, Kranick, who's like the quintessential judge, Judge Jackson, they all get petty. She's like, I think this is the 5th time that I've asked you now, or told you now, or, you know. Then she starts counting, like Judge Kranick with the pages of his letters, and just, because you have to.
For page 2 of the relocation with the parenting plan, it says that it will dramatically improve the economic circumstances of the petitioner and the minor child.
So I'm going to object because as the relevance, because I'll let her finish her question. I'm sorry. Finish your question. I'm sorry.
It's part of
Sorry, Ms. Boone. Go ahead.
How has it improved your economic circumstances considering the fact that you are in quotes unemployed?
So now I'm going to object, Your Honor, as the relocation was already stipulated to, so now irrelevant. Irrelevance.
All right, I'm going to sustain the objection. Again, ask questions regarding the issues that I just gave you. We've already stipulated, you've already agreed to the relocation to, okay? So the only issue with regard to relocation is the proposed parenting plan.
So the overall plan starts off with every other weekend from Friday evening until Sunday evening between the respondent and the minor child. How is any of this even applicable considering the fact on that DOC?
I think that's the whole point of this, ma'am.
I'm not sure what I'm supposed to do. And am I supposed to object to it? Because I object to it.
All right,
It doesn't
we're here
make
for a
sense.
final hearing. Whether or not you object to it is not relevant at this time. The court is going to make a decision based on the evidence that is presented today. The court's question for you, do you have any additional questions for Mr. Boone regarding the proposed parenting plan, the request that the alimony be...
Right, Tony Tim. Yagarita got it right. 100%. She doesn't know how to act. It's like she's an alien from another planet trying to fit in. A nasty, vindictive, sadistic alien from another horrible planet.
discontinued, or the request that the child support be discontinued, or the request for attorney fees.
If you could just give me a moment, please.
Okay?
Forgive me, I don't know what I'm supposed to be doing with this relocation. For the relocation parenting plan, which I was not aware of, this was on our to-do list today. I thought it was the original parenting plan. I don't know what I'm supposed to do or how I'm supposed to answer this. Brian, how can I exercise every other weekend from Friday evening until Sunday evening between the respondent and the minor child?
You can't.
How can prisoner and respondent alternate winter break and Thanksgiving time sharing?
You can't?
Why has this been proposed in regards to relocation when I am here?
I'm confused.
All right, next question.
So the amended parenting plan with my understanding that it is up to the child to have contact with the phone as regular as he would like to have.
I don't think so. I don't think that's what we're proposing.
It says the parties will coordinate a weekly phone call between the child and the mother. After all regular, consistent phone calls that he and I have been having, now it's going to go down to one phone call.
Yes.
Yes.
Do you think that would be detrimental to him?
No.
Or do you think that would be helpful?
No, I think
She is, Michelle.
every weekend you can call him and catch up on how his school week went and everything like that.
Why are you doing that?
Because I think that's all that's really necessary. And these phone calls start to add up.
So in the past, we have been speaking to one another on a regular basis about everything. I have been included in his life because he has decided to answer the phone call and you pay for the call. Now, because of this, you're going to allow us one 30-minute phone call per an entire week.
No, you could have 2 phone calls. You could have 2 back to back and talk to him for an hour. That's fine.
She neglects to mention that for the 49 times she'll call him in a day, he'll answer once. I mean, of course he decides to answer the call. Eventually.
And I mean, if it's a birthday or a Mother's Day or a holiday, I mean, yes, there will be other things worked in, but I don't think you need 7, 8 phone calls a week. It's ridiculous.
Is that due to payment or because it's harmful to speak to him that many times?
Both.
How is that harmful?
Once again, I see him very upset at the way you talk to him all the time after phone calls.
When was the last time he was upset?
Probably about a week ago because you didn't call all last week.
Do you know my schedule of work while I'm located at BOC?
No, of course I don't.
Why haven't you asked about it? To know that.
Because I don't care.
Is it true that we just spoke to our son and told him that he has the authority to choose when to speak to me and how often?
No.
It's
He
his
told
decision.
He told me he would like for it to work that way, but it can't work that way. He's a minor.
Yeah, I'm
Why do you not care?
About you.
Question, ma'am.
I'm sorry, Your Honor.
Scripsy, get out of my mind. Scripsy says they think I should hold a Sarah Boone poetry contest. First of all, don't tell anyone, people. And try to forget this immediately after I say it because it's very embarrassing. But I wrote a poem about Sarah last night. And I was like, this is fun. I should have a poetry contest. Not a contest, because I don't believe people should win or lose at things. But I mean, some of them should, obviously, but, you know. And then I thought maybe I'll have Dandy do, illustrate, do little videos for whichever ones he wants to. So I'm going to do that because now you have confirmed. that it's a good idea. Thank you. Start writing, people.
We're way off target here. Let's move on to something else. If you're done, you're done.
Yeah,
Your
bitch.
Honor, thank you. Forgive me. Have you at all upheld any of the other items in the active parenting plan to date since of my incarceration?
For instance?
I'm going to object as to overbroad and
Sustained. Ma'am, you have to ask a different question.
Communication. Between parents, all communications regarding their child shall be between the parents.
Okay.
Have I tried all possible forms of communication in regards to phone calls, tablet messages, handwritten letters, texts from outside resources,
You're
etc.,
done.
to try to communicate with you in regards to communicating with you about our son?
Yes.
Have you responded?
You've already been over this. Next question.
For the active parenting plan, it says it may be modified or varied on a temporary basis when both parents agree and sign it and write it. Have you signed or written anything, or have I?
What, to modify? That's what I'm trying to do.
When the
I'm gonna object
parents do
as to
not
relevance.
agree, the plan remains in effect until further order of the court. Has
All right,
this
ma'am.
been
Also, she has nothing to do. What does she need outside resources for? She literally has nothing else to do. She has a legal library. She has a family court book that her poor brother probably went into hock to get her. Why does she need to use other people and then complain about their work?
Ma'am, you're beyond the issues we're here on today, okay? Next question on those issues that I've gone over with you over and over again.
Forgive me, I'm trying to do my best without knowing what I'm doing. For the objection to relocate, how soon before the actual relocation did you tell me?
All right, again, that's not relevant to the issues we're here on today. The relocation to has already been determined, okay? Specific questions regarding the proposed parenting plan that was admitted into evidence as Exhibit 1, the request to stop the child support, the request to stop the alimony, and the request for attorney fees. Do you have any questions, any additional questions on any of those issues?
Yes, Your Honor. I don't know if you can answer this or not. I just don't know about asking you. Are my questions after this? Is that the end of it? I mean, I don't know how much further this goes for me to be able to utilize my pretrial statement information.
All right, as I explained to you at the beginning of this process, I will do it again. The petitioner has the burden in this case. They get to call the witnesses, they get to introduce evidence, okay? Once they are done, then I turn it over to you so that you can call any witnesses or you can provide any documents that you want the court to consider. I also want to say to you, it is now 3:06 p.m. We will not be going past 5 o'clock. So the more you continue to ask questions that are not on the issue that we've talked about today, the less time you will have to present your case.
I don't know if you can Okay. In regards to attorney fees, is having an attorney a choice?
Yes?
Sweet baby Jesus.
Were the dollar amounts that you put in my commissary account considered voluntary?
They were partial payments to you, as we had discussed when you first got in there.
He's like, bitch, are you drinking?
On your pretrial memorandum, they're stated as voluntary.
Objection, there's no question.
Why? How many times that you can recall did I try to inquire about a guardian ad litem with you?
Objection, relevance.
All right, ma'am, can you repeat your question for me?
How many times did I attempt to obtain a guardian ad litem with him?
I'm going to sustain the objection. Next question.
Do you drink?
Yeah?
This is my favorite.
How often?
Objection, relevance.
What's the relevance of how often Mr. Boone drinks?
Because he's making my, in quotes, drinking problem and blaming a lot of things on what happened to me. And I wanted to find out if he did or did not.
No, he's not blaming your, in quotes, drinking problem on things that happened to you. He's blaming you for your drinking problem and the things that you did.
Currently, while he has our child.
Yes, Zach.
You want to know whether or not he drank while he had the child?
Yeah.
Yes, well, if he drinks while he is in the presence of our child.
All right, I'm going to overrule, and I'm not letting this go too far astray. You can answer the question, sir.
I have had a drink in front of our child before.
Okay. Did you have a conversation for a split moment with our son the other day? So you had the understanding when he was asking about the application that you do not live an hour and 20 or 30 minutes away. You came to the understanding correct that it's only 50 minutes away, 50.
I think it's further than that when I did it on Google Map.
Your Honor, I'm not sure what else I'm supposed to do, so I guess I'm ending whatever part I'm supposed to be doing.
All right. Any redirect? Let me just ask you that.
No.
All right. No redirect. We're going to stand in recess for 10 minutes. We'll come back at 3:20 p.m.
Thank you.
Deputy, do you need a break?
Everyone needs a break. Hi, Hot for Hillside.
Miss Boone, are you there?
Yeah, say Chris, it is.
I'm here, Your Honor.
Okay. All right. I don't know if I may have accidentally hit mute again. We just located your exhibit that was entered into evidence as Exhibit 1. The clerk now has that. Before we took a break, Petitioner's Counsel indicated he did not have any additional questions for Mr. Boone. So now I turn back to Petitioner's side and ask, do you have any additional witnesses or evidence you would like the court to consider?
I would call Miss Boone very briefly.
Please do.
All right, Mrs. Boone, counsel has some questions for you. And once he is done what I'll probably do is I'll ask you, do you have anything that you want the court to know right away based on the questions that he has? And then we'll get and see if he has any additional witnesses and evidence, and then I'll turn it over to you for your presentation, okay?
Yes, Your Honor.
All right, you may inquire.
Thank you, Your Honor. Ms. Boone, you filed a financial affidavit in this case on May 30th, 2025. Is that correct?
One moment, please, and I'll pull it.
Hi, hello, baby.
Go ahead with your question while I'm looking for it.
Well, I want you to locate it first because I want to ask specific questions about specific pages. So I'll wait for you to locate it. Did you receive the exhibits that we sent you? Because it also would be in that packet as well.
Zach Ease says, Sarah killed someone and the first thing on her mind is a Dr. Pepper.
I have it located.
Okay. And that financial affidavit that you've located, that has a stamp on the top of it that says that it was filed at 1:08 p.m. on May 30th, 2025. Is that correct?
Yes.
Okay. At this time, Your Honor, I'd like to submit what has been previously marked as Petitioner's Exhibit E, which is the respondent's financial affidavit filed on May 30th, 2025, into evidence.
Any objections to the court considering your financial affidavit that was filed May 30th, 2025, Ms. Boone?
No, Your Honor.
All right, hearing no objection, I'll receive into evidence what was pre-marked as E as petitioner's number 3.
Okay, ma'am, I just wanted to ask you a few questions about your affidavit.
Hi, Senor Avocado Man. Thank you very much. Glad to see you here.
David. And I'm going to just laser focus right in on your expenses section, which starts on your page 6 of the document, and for the court's following of my exhibit, bait stamp page 46. Let me know when you're there, Ms. Boone.
I'm there.
Okay, so this section here is going through what you estimate to be your expenses. The first question I had for you is,
What the fuck is wrong with you?
have these expenses changed dramatically since you started your incarceration in February of 2020?
They haven't changed because they've never started. It's just an estimate from going off of the canteen list.
Okay, so from February of 2020 until today, you have not actually incurred any of these expenses that you've listed on your financial affidavit. Is that correct?
You're asking me from when I was at Orange County?
April.
Yes.
To the present day.
Yeah, I asked you the question about these expenses, and you said you mentioned something that you haven't actually incurred these expenses yet. So that's what I asked a follow-up question to that of, are you telling me that since you started your incarceration in Orange County in February of 2020 until today, have you actually not incurred any of these expenses that you've listed here on your financial affidavit?
What do you mean by incurred, please?
Have you had to pay them?
Have I had to pay for food? Yes, I have.
Okay. So, has it stayed though? My first question to you though, which you answered it in a different way, so I want to answer it again. I ask you again is, for example, you have here on your financial affidavit that you filed in 2025 that your food expense is $250. My question is, has that number gone dramatically up or gone dramatically down, or has it stayed relatively the same since you started your incarceration in February of 2020?
I don't know or remember in regards to my incarceration 5 years ago, but I know for the current time, this is just an estimate because the prices fluctuate. So as of right now, it's about the same.
Now, does the facility that you're incarcerated in, does it provide you meals for free?
It does.
Okay. Does it provide you breakfast, lunch, and dinner for free?
Yes.
Does it provide you any other meal times other than those 3 times for free? Snack times or anything like that?
No.
Okay. Does it provide you things to drink for free?
Water, yes.
Okay. So when you
This bitch.
indicate here that you have a estimated food expense as of May of 2025 of $250, what is that for?
That is for my low blood sugar, which the petitioner is aware that I have ongoing and need to maintain my blood sugar. My grandfather died of diabetes, and I have to maintain that with snacks and in between meals. Some of the meals are, of course, unappetizing, and my stomach is not able to handle them properly, so I either do without or would.
First of all, you should always do without. You can starve to death for all I care. And what the fuck does that mean? Your stomach is not able to deal with them properly. And the petitioner is aware of my glucose concerns. Of course he is, because you never shut up about them. But do you realize that there are medical records at that prison? And that every time the doctors see you, they talk about what they write down in words on your record, what medical issues you have. And yet she comes here and just bullshits Judge Jackson, who must really
Fall
be
back on something that I
pissed.
could order or purchase from Canteen.
And are you actually incurring this expense in purchasing
Right, Zay Chris.
additional
And everyone's grandfather had diabetes.
food above and
Fuck's sake.
beyond what the prison is offering you for free?
I wouldn't be a good
I
judge. I'm too
have
angry.
from contributions, yes, but on a regular basis, no.
Okay. Explain to me these contributions. What are you talking about when you say from
Ditto,
contributions?
I have a friend that will deposit money in my account on a rare instance when she has an extra or something spare.
Okay. Do you have any other contributors?
My brother, when he's able to.
So if I understand you correctly, this food expense is not for breakfast, lunch, or dinner. It is for supplemental food that you believe is appropriate due to your blood sugar. Is that accurate?
Yes, and also in regards to the meals not being able to be digested properly.
Okay.
Primarily for medical reasons.
And then you have on here another charge of $100, or another expense of $100 for gifts for holidays. Is this for gifts for your son?
Yes, that's under child expenses.
And is this $100, are you asking that Mr. Boone pay you this so that you can give gifts to your son?
Would he be paying the alimony arrearages or any dollar amount? Yes, I would like to have that deducted from that dollar amount because I don't have income on a regular basis.
Okay. So you want your husband to give you alimony
Out for the hillside.
so that
My
you can,
ex-husband.
you're right, excuse me. You want your ex-husband to continue to give you alimony so that you can then turn around and purchase gifts for your son on your behalf because you cannot purchase those gifts because you're incarcerated. Is that correct?
My alimony payments can be spent however I make or decide how to do so. And yes, I would like to include my son for gifts on holidays or just because I love him. Yes, that would be a part of my disbursement of my alimony.
Hi, Ravina.
Do you think it's fair for Mr. Boone to give you money to purchase gifts for your son that you can't afford to purchase because you're in jail? You think that's fair to him?
Alimony is court order, which
Okay.
is unfair that I have to not be paid what I could have been paid.
Okay. You also have on here that you have a $200 communication charge. Is that for the phone calls that we've been talking about?
That's for all of the communication opportunities that have not been taken advantage of by the petitioner. It's not just phone calls. It's video visits, videograms, cards. It's a multitudinous amount of technology that is available to be utilized if decided to.
Every effort, every expense that's been incurred. Oh, I'm sorry. Do you want to finish your point?
No, I was just stating that it is located in my exhibit, so you all are aware of the opportunities
All right.
and the cost.
Okay. I want to be clear, though. Every expense related to you communicating with your son, since you've been incarcerated, Mr. Boone has paid for that. Is that correct?
It's my only form of ability
Ma'am,
right now.
answer
yes.
the question. Has the communications with the child been paid for by Mr. Boone since you've been incarcerated?
Yes.
Okay.
Next question.
You have a $50 charge here for clothing. Does your prison provide you with clothing?
Yes. The prison
Okay.
provides uniform.
Okay. And then you have $15 here for medical and dental. Does the prison offer you any medical services?
You have to have a lien against your account. To make a sick call, you have to pay for that. For dental, you have to pay for that. Regardless if you have an insurance plan or not, you still have a lien placed against your account.
Okay. And you are estimating that your cost for that is $15 a month on your financial affidavit. Is that correct?
Yes.
Okay. And then you have here other hygiene and writing items. Does the prison provide you with basic hygiene items?
No. The prison
Love
only
this.
supplies I believe, 1.5 ounce all-in-one shampoo and body wash, toothbrush and toothpaste.
Okay. Those would be considered hygiene items, correct?
Yes.
Okay. And you have here a $50 charge for creditor Department of Corrections. Are you indicating that you owe the Department of Corrections money?
This is the
Thank you, Tanika. That's so nice of you. And anytime, we're here for you. Rant away. Least I can do is return the favor. You know, you've done it many, many times.
They're all estimates. And you need to please remember that I am new to DLC and don't understand, but I do know that weekly draws pulled from everyone's account every week. So depending on how much money you have in your account is how much they deduct from your account. This was just an estimate. I'm not even sure how they go by what they do, but this was what I was told to do from one of the classifications officers. And a lot of these that you see at the bottom, it states estimated for all. The clothing is charged quarterly. It's not every month. And there's limited quantities, and also the prices fluctuate, which is why I included those as my exhibit so you all would understand the most current pricing.
Hi, Winterlake. We don't know why this is happening. Possibly because George is dead and she was a terrible mother even when she was free. And she's a horrible person in general and she doesn't know anything at all. And also the pre-sentencing statement did not know.
Other than receiving
Other than this,
contributions from third parties and receiving money from Mr. Boone, since you've been incarcerated, have you had to pay any money out of your own pocket to meet your day-to-day needs while you have been incarcerated?
Sir, I have no money.
I'm sorry, I didn't understand your answer. What did you say?
Sir, I have no money.
Okay.
hi EDB. Sorry to interrupt Sarah's role playing as Oliver Twist, but I just wanted to say hi to you.
So the answer would be no.
Correct. No.
I have no way of doing so. No, I do not have any way of paying.
I have no further questions, sir.
All right. Ms. Boone, I will give you an opportunity to talk about the financial affidavit in just a minute, but I'm going to ask counsel any additional witnesses.
No, Your Honor, I just have some reserve a little bit of time for closing argument.
All right, any additional evidence?
No, Your Honor, just some demonstrative aids that I'll be arguing closing.
Hide your money, y'all. There's poor people around. Thank you, VC. I appreciate that. Sir, I have no porridge. Sarah's broke ass.
All right, Mrs. Boone, counsel has indicated that he has no additional witnesses or exhibits for this court to consider. I am now turning it over to you to present any evidence that you want this court to consider and any testimony you want this court to consider. And that includes any testimony or any explanation or additional testimony you want to provide to the court regarding your financial affidavit. Once you are done, counsel for petitioner will be able to ask you some cross-examination questions as well, okay?
Yes, Your Honor.
All right. And again, I'm going to say to you again, the topics we're here on today is the proposed parenting plan that was admitted into evidence as petitioner's exhibit number 1 that was pre-marked as G in the packet of materials that you received, as well as the request to have the alimony of $1,000 per month discontinued and the issue of child support of $100 per month discontinued and the request for attorney fees. Those are the only issues the court is considering today. Those are the only issues that you will be permitted to provide evidence on at this time. Okay?
forgive me, it's Exhibit G, the proposed amended parenting plan, the attorney fees, and what was the last?
The request to discontinue alimony and the request to discontinue child support, which I think you said you agree that he should not be paying child support as of February of 2020.
Okay. So parenting plan, attorney fees, and alimony.
Correct.
Okay.
Exactly, Jackie. Showstopper.
So for the parenting plan,
That's a good question, Paige. Paige asks, how can she be so stupid? I'm going to propose that question to the floor.
I would like please to put into evidence my number 2 and 3. I'm sorry. The parenting plan, the original one. My number 2.
All right, give me just a minute.
Where it's signed by those parties.
Yeah.
Counsel, do you have any objection to what Ms. Boone had pre-marked as Exhibit 2, which is the parenting plan that was filed with the court back on May 9th of 2018 coming into evidence?
No, Your Honor.
All right, hearing no objection, I'll receive us into evidence what was pre-marked as Respondent's Exhibit number 2 as Respondent's Exhibit number 2.
Yeah. Last night's video, as Tanika is mentioning, made me more angry than even I expected because, I mean, I'm very used to being so angry when anything comes out that she has said or done. But this was, hi, Susan Bareback. This was so incredibly disgusting. And she doesn't even realize it, which makes it worse. So we have some of the reasons that you all have said for why, how can Sarah be so stupid? Is Michael Huang said, blame the wine. A to B says she excels at everything, including being stupid. Marielle said, what do you mean? She's a straight A student. Her brain is pickled from alcohol, Seba says. Winterlake says, because pride, arrogance is blinding. And Margarita said, the answer, pure narcissism. Yeah.
All right, what was the second document?
The second document is the certificate of completion for the parenting and divorce class, my number 3 and 4.
Dandy says maybe there's something wrong with her medulla oblongata, and then he says it's a quote from Waterboy. But I think of a song when I hear that by Isaac Hayes. If anyone knows that song, tell me what it is. I know what it is, but you know. Hi, Bully Dad.
For the record, I have here what Respondent marked as 3. It is a parenting class certificate that was filed back on April 24th of 2018, and which is pre-marked as 4, is the parenting plan certificate filed back on May 15th of 2018. Any objection to exhibits 3 and 4?
No.
All right, I'll receive into evidence what was pre-marked as 3 as Respondent's Exhibit number 3 and what was pre-marked as 4 as Respondent's Exhibit number 4. All right, what's next, Ms. Boone?
Am I allowed to explain that?
All right, I don't know that any explanation is necessary, but go ahead.
In regards to the parenting plan, first and foremost, I would like to say that one moment.
One moment. Yes, Your Honor.
From my parenting or from my pretrial statement, please, I would like to say that my incarceration has nothing to do with me as being a human being and a mother to my son. I've done everything I possibly can to be a part of his life regardless. And with the active parenting plan, my former husband has excluded me from my son's life in every way, shape, and form and alienated me, which is not part of the active parenting plan. So since 2020 of my incarceration to the present date without any modifications, he has followed
Page says, shockingly, Sarah did not catch the judge's hint.
the parenting plan in regards to trying to encourage the relationship as discourage the relationship. The point of my certificates of completion are to show the different topics that were covered in the court-ordered class that he had the understanding that he was supposed to abide by in regards to acting appropriate towards the other parents in front of the child, which he has not done. And the burden of proof is on the opposing party to show unfitness, and I shouldn't have to prove my worthiness. And I've done everything I possibly can in regards to be a part of my son's life. And as you heard the petitioner himself say, he doesn't care. He does not answer my phone calls. He does not answer my chat messages. He does not respond to my letters. He's not made any attempt to find out any contact information. He's not done anything in regards to have me be a part of my son's life, and is now going from having me speak to my son on an almost regular basis down to 1 30-minute phone call. I believe that is more detrimental to my son as opposed to helping him when I have had my parental rights intact since day one of my incarceration, and have helped my son since the day he has been born. And I don't believe that they should be terminated, or a 30-minute phone call should be viable.
Sandy Rodriguez, she didn't go through her phone before going to the police station, because she didn't go to the police station that day. And as soon as they asked her phone, because she wanted to seem so, she figured if she could just act so accommodating and like she's got nothing to hide. And she thought her phone was filled with the horrible videos we saw, making her look like a horrible sadistic abuser. She thought those videos made George look bad. So there's that. And I don't think she remembers half the shit she did. Clearly she doesn't. So she didn't have time to look through her phone, because she's like, it's in the kitchen. Sure, take it. Idiot.
Because no alternative exists. My parental rights should not be taken away. That should just be a last resort, and I don't know why he's doing it, and I am used to him saying he doesn't care. And I believe that my rights should be preserved, and I have all of my case laws stating such. So I don't know what I'm supposed to state that, or if this is my opportunity. I don't know what I'm supposed to do. The minor child is very aware of these ongoing hindrances and speaks about to the respondent and his desire to see her in person, which she also has been asking petitioner about almost on a daily basis. The minor child apologizes to the respondent regularly that the petitioner does not do and prolongs their overdue time together in person. The multiple children's rights he has violated in regard to developing an independent and meaningful relationship with each parent because of the petitioner. He is present during the parents' personal battles while I'm trying to speak to him on the
Chris.
phone. To speak ill will, he has called me murderer and killerer in front of my son, which is another reason why I wanted to have a guardian ad litem, which has been denied. I believe. Has had my parental rights intact since day one of my incarceration, and have helped my son since the day he has been born. And I don't believe that they should be terminated, or a 30-minute phone call should be viable, because no alternative exists. My parental rights should not be taken away. That could just be a last resort, and I don't know why he's doing it, and I am used to him saying he doesn't care. And I believe that my rights should be preserved, and I have all of my case law stating such. So I don't know what I'm supposed to state that, or if this is my opportunity. I don't know what I'm supposed to do. The minor child is very aware of these ongoing hindrances and speaks about to the respondent and his desire to see her in person, which she also has been asking petitioner about almost on a daily basis. The minor child apologizes to the respondent regularly that the petitioner does not do and prolongs their overdue time together in person. The multiple children's rights he has violated in regard to developing an independent and meaningful relationship with each parent because of the petitioner. He is present during the parents' personal battles while I'm trying to speak to him on the phone. To speak ill will, he has called me murderer and killerer in front of my son, which is another reason why I wanted to have a guardian ad litem, which has been denied, I believe, 3 times. He doesn't include me in any way, shape, or form in regards to anything that has to do with my son's life. I know a lot about my son. I know what his favorite color is. I don't believe that petitioner even knows that much. The name of his girlfriend, the things that they're going through. I am part of his daily life. And for him to take that away from me is just out of bitterness and spite. I want to be a part of my son's life. And people forget that I have a pending appeal.
Right, Robin. She thinks she has rights just because she gave birth to this boy. I think you may have not been here before. I asked a question. I was just wondering if you think that, Brian's offer, his proposed agreement, to me seems very, almost unrealistically generous. Once a month is a lot to go for a child, a young man, young whatever, to go visit his mother in a prison that's half an hour and a half away. And do you think, or is it that his lawyer probably told him it's better to sound generous and come off, if anything, too accommodating, because certain things they can't make you do and they won't make you do, like you won't be held to the prison visits, or you know what I mean?
So to prove my innocence, which is what I've been doing since day one, the reason why I was incarcerated at Orange County for over 5 years, or at least 5 years, was because I continued to fight for my case. I know that the petitioner understands the reasons why it's the equal 30% time sharing, because of the danger and safety. There's a lot of things that I was trying to protect my son from. I'm not that parent because I was trying to make sure he was safe and in a safe place. The time sharing, of course, it makes no sense to have the, well, the relocation one is not what we're talking about now.
She finally had a moment of realizing
I do not
anything.
feel that it is right for me to have a 30-minute phone call with my son when I'm trying to do everything that I can to be in his life in every way, shape, and form that I possibly can, from having people in Australia purchase him a record. Anything that I can possibly do to go out of my way to do, I've been doing for him. So he remembers and knows that I am in his life and I am his mother, and I am doing everything I possibly can to stay that way, regardless of the petitioner and his counsel's attempts to deter me from being part of that. I try to communicate with the petitioner in regards to my son. I've been continuously excluded. There is no communication. I don't know what else it is that I can possibly do that I haven't tried to already. And a lot of these too, I would like to remind everyone, is these could have been solidified where they have had the meeting of attorneys and unrepresented parties meeting. A lot of this could have been had and resolved and narrowed if we were to have that meeting in regards to all of this. Nonetheless, if the petitioner would have answered a phone call or a tablet message, it's not fair to me that just because I'm here, it doesn't justify how I've been treated and excluded with it. I would like to continue to have the regular phone calls and interaction with my son, which I have been doing, and all of a sudden now is being tried to be taken away from me out of sight, as opposed to my son and his growth and him moving properly and appropriately and lovingly forward with his mother. And I would very much like, please, after 9 months of asking for my son to please come see me, which is only 50 minutes away, which I think will change both of our lives with finally being able to see. I don't know if you can hear me, but there's incredible feedback. Static.
All right, we can hear you. You can continue.
I can hear you.
I would like, from the parenting plan, my resolution, please. If I need to, I don't know what I'm supposed to do if I say it again. If that's on record from previous, but the daily telephone call, personal space for him to grow up as the teenager that he is. He's going to be a legal adult in 3 years, which is why I'm unclear on why he's fighting for this. So the petitioner, nonetheless, I've not been included in anything major or included in an ending period since day one. So I don't understand. But I'd like to have, please, tablet messages, all of the teachers.
Thank you, Jode. That's very generous and kind of you.
Everything that I can possibly
appreciate you. Sorry, Sarah, I didn't mean to talk over you. When is she going to say, can I object? Because I object. Did we miss that? Did I miss that already? Thanks, Jode.
not still pleased to be in my son's life. This is another reason why, too, that I was trying and adamant to have a guardian ad litem appointed. And I believe that I would like to suggest that some kind of co-parenting course or counseling in regards to how to treat the other parent, which he has already.
So Robin says, we need to remember that this whole process is a 4D chess match, and Brian is playing the long game to get what he wants eventually. Yeah, I got to give it to Brian. He has the patience of a saint. I mean, I would have tried to strangle her in this hearing. Somehow, I would have gotten into the car, drove over to Lowell, and just been like, "Where is she?" To get what he wants eventually. Those released phone calls will be Exhibit A for petition to terminate. Right. And I mean, I didn't know that, but I certainly know that they probably will not do her well in her pending appeal and in this situation, but she doesn't care because she just wants to get her nastiness out there. And that's V. Lopez. I saw your question about discussing the newly released calls, and I don't want to talk about them for the same reason that I don't like to talk about her elocution, because I don't want to get her disgusting, completely 100% not truthful mission statement out there. She's just, all she does is insult everyone else and act like she's a saint. And it's just the same thing over and over again. And I don't feel like giving her a platform for her total bullshit. None of those calls are real. I mean, they're all, they're PR for her, you know? And I think it's revolting. Where were we?
Taken, but back in 2018 upon our original divorce. So I think he reminded please on how to treat the other parent and also look out for our son's emotional distress that he has been causing him by calling me names and not speaking to me and giving me the silent treatment when I'm trying to speak to him solely in regards to my son. I'm doing everything that I possibly can for my son.
My son.
I've been avidly striving to and will continue my pursuit to be even more meaningful to my son in my continued hard-fought efforts to see him in person while temporarily located at DOC and in the meantime of my appeal and my release and all other positive aspects that I have with my son on the horizon. I've encouraged him, acknowledged him, understood him, listened to him, believed in him, and I make him stronger and more beautiful.
No, you don't.
Foremost and above all, meaningful means love, which the respondent ceaselessly and immeasurably will always have a wholeheartedly provide for her son, which is priceless, and no circumstance or agreement or modification in any lifetime can change or end. I'm hoping that the court can see my ceaseless attempt and whatever it is that I can do in order to stay in my son's life for longer than 30 minutes per week, please. I have a lot to offer and I can help him grow in multiple ways. And I am his mother, and I wish that I had the guardian ad litem or my son to be included in this, which if I can also include, please, into evidence my it's the notice of filing the respondent's answer, the supplemental petition for modification of final judgment, which is number 7, please.
Hey, give us just a minute. You said number 17?
7.
7.
Yes, Your Honor.
Give us just a minute. We pulled the wrong one. Right. So what I have before me is it looks like petitioner filed a handwritten document on it's dated May 1st of 2022, but it looks like it was filed with the court on May 16th. And there was a notice of filing by Attorney Martell looks like he may have received a copy and he filed it with the court. Is that,
Let me just pull it up, Your Honor, I'm sorry.
it's okay. But I am seeing it both in the court file on May 16th of
Is it an answer to our petition?
Yes, and it looks like you may have filed a notice of filing just to make sure it got into the
Yeah,
court.
I no objection.
All right, so I'm going to receive what is presented as Respondent's Composite Exhibit 7, which is that notice of filing by Attorney Martell, as well as the actual handwritten answer. I'm going to receive that into evidence as Respondent's Exhibit number 5. All right, Ms. Boone, you may continue.
This was just me trying to be transparent with the petitioner's counsel and describing to them my need and want to be in my son's life back in 2022.
Yeah, I agree with what Marguerite is saying about how it's just to show off that she wants her son to visit. It has nothing to do with her wanting to. She's not even, I don't even think she can think on that level. I don't think she understands anything about emotions, but I do think that other people's children and families are visiting them, and she doesn't like how that makes her look. And people are probably side-eyeing her anyway because she's crazy. She put someone in a suitcase and let them die after mocking them, and she's not so likable, you know. I mean,
Explaining my dedication and my decisions and ideas and opinions, they matter. One obscure enforcement incident does not define me as a person or my entire existence. And I'm trying to be my son's best advocate for myself. And two parents are involved.
right. Thank you, Seba. Or Kaba? Probably Seba, right? When Sarah calls, put the phone down every couple of minutes, come back, say, uh-huh, and she'll never know the difference. Exactly, because you know she's not letting anyone get more than an uh-huh in edgewise. Thank you.
Just because I'm not there under the same roof to make the same decision, or at least I would like to be conferred with and included on so I know what's going on in the son's life. This is just me trying to know what is going on and to let them know what I'm striving for in order to come to some type of cooperation or collaboration. It was just me emphasizing to them that I very much would still like to be in my son's life.
Oh, fuck you.
That is my letter originally in answer to their modification of this final judgment, which we are in the process of debating. For also the parenting plan, which is still active, the original from 2018, I believe, I wanted to bring to the court's attention that it's been violated by the petitioner. Again, from previously, now I believe it's a time where it says the parenting plan may be modified or verified on a temporary basis when both parents agree in writing.
All right, Ms.
When the
Boone, you
parent-
have to, Ms. Boone, you have to agree that there's a lot that's not being followed with regard to that parenting plan, which includes even the time sharing that you're not able to do at this time.
Right.
You would agree with that, correct?
I understand that, but that is my only stipulation. That's my only part
Okay.
that
All right,
I'm
you would
unable to
also
apply-
agree that that parenting plan was entered into back in 2018 prior to there being any criminal charges in your incarceration. Do you agree with that?
I do, Your Honor. But it
Okay,
was
and you
still
have
an
to also agree that when the parenting plan was entered into, if I remember correctly, you all agreed to the parenting plan as part of your mediated settlement agreement back in 2018. And at that time, neither one of you were contemplating any type of criminal charges or incarceration. Is that correct?
Yes, Your Honor.
Okay. All right, you may continue.
So I would like to bring in the part of the divorce certificate, which include each parent and everything they're supposed to abide by regarding being appropriate to the other parent, regardless of incarceration or not. That's what I was trying to say. I've been excluded this entire time, and everyone has blamed my incarceration on it, which it shouldn't be like that because I'm still the mother of my son regardless of where I am. And what petitioner has been saying and doing and not doing are unacceptable and to a certain extent unlawful, especially with the active parenting plan. It shouldn't be done anyway, with trying to hinder my relationship with my son. There's no reason for him to do that. And again,
If you
in
don't mind, please.
conclusion, the continuation of his responses, I don't care. That's what I've done since I've been here. So do I bring case law up right now, or is that something I can?
All right, if you'd like to bring up case law, you can.
Okay.
Me too, Joette.
So,
Oh God, now she's gonna do case law.
I'm looking. Excuse me. Thank you for your patience.
Ugh.
Children. Okay.
I didn't want it to be like
In
that.
regards to children in the parenting plan, Hunter versus Hunter, the court ruled that incarceration in and of itself is insufficient to terminate or deny custodial rights unless continued contact is shown harmful or detrimental to the child.
All right, give me the
Hunter versus Lamb and also Lamb versus Lamb.
case name again.
Hunter v. Hunter,
All right, do you have a case citation?
yes, Your
The
Honor,
number, okay, give that to me.
540 F as in Sam, O, 2, D as in dog, 235, in parentheses, FLA, 3, D as in dog, DTA, 1989, in parentheses.
189.
Yes, 1989.
Yeah, see, but that's another thing. She. Right, Sophie. Two morons working together for an even bigger
All right, you
moron.
may continue.
Thank you, Your Honor.
Kramer
Also
versus
for that
Kramer.
case law, the court has discretion to restrict visitation only to protect the child. The petitioner cannot.
Tina's comment says, I love this community. Thank you, Suma, for hosting. I do too, Tina, and it's really something I never expected. I mean, I knew this community, of course, because I've been watching Sarah Boone videos since we first learned about Sarah Boone, and I've always loved it. It gets stronger and stronger, and it's very encouraging and comforting. It's great. Thank you for your support.
Penalize the respondent for her incarceration. Also, it reinforces that inability to communicate, not incarceration,
Right,
is the key
Tina.
benchmark for limiting shared parenting. I have multiple ways of trying to communicate with my son. And I've been trying every single one and trying to share parenting as best as I possibly can while located here.
Thank you, Joette. And hi, Super Kelly.
And spec versus spec,
Oh, spec versus spec. Right, RN, to, it's one of the things like, I don't worry about growing my channel because I don't want, I mean, not that I have to worry about it necessarily, but I like it being a controlled environment that nobody feels, like I had kind of like I had my chats and my comments moderated to like the basic degree, just because I was like, I mean, I have no idea what's going to come out of this, what's going to happen, and then of course I realized that it's really I get hardly any nasty, unpleasant comments so far. Nobody's come into the chat and done anything untoward, unseemly, and that's why I do the thing where you have to subscribe for at least, because I figure, well, I mean, if it's a troll, they'll just move on, If you don't belong here, I don't want you here.
I'm sorry, were you done or are you looking for your
oh
next
no,
topic?
forgive me, I was reading another case law to you.
All right, I have the Hunter case. I've gotten that. Do you have another case?
Yes, I do, Your Honor.
All right.
Please.
All right, hold on, give me just 1 minute.
Dandy. Dandy says spec versus spec sounds like a tiny case.
Thank you for your patience.
Thank you for your patience. I mean, let the case law go, you lunatic.
All right, your next case?
Oh, fun. Super Kelly.
Ogilvy, O-G-I-L.
I'm going to pause to thank Esme before we get into Ogilvy. Thank you, Esme. You're very kind and very supportive and very lovely.
V is in Victor, I-E.
All right, just give me the citation for now.
Forgive me, 2007 FL 2D DCA. Ogilvy versus Ogilvy.
Gail Marie, I used to tell my dog all the time, there are dogs who have jobs. You don't do a damn thing around here. He was not interested in being employed for some reason.
All right, you may have to give me the spelling of the name again. Go ahead, O-G.
I-L-V-I-E.
V as in Victor.
Yes, Your Honor.
Friggin' poop. Hi, not intentional. Welcome. We're not just sitting here listening to nothing. We're listening to long pauses while Sarah Esquire looks for her case law, which doesn't apply to anything she thinks it does, and most of it doesn't exist. Welcome. Good to see you.
This holds
All right,
that.
Jennifer, hold on. Jennifer Ogilvy versus Dale Dean Ogilvy.
I don't have their first names, Your Honor. I just have Ogilvy versus Ogilvy.
All right, well, the case citation you gave me is not a formal case citation, so I have to figure out if I have the right case here.
If I
All
may,
right, go
can
ahead
I
and tell me
please-
go ahead and tell me your position on what you believe the case states.
It holds that parental alienation taxes, like disparaging the other parent or withholding visits, constitute interference and harm for the child. I have limited resources at the law library, so forgive me.
No,
Oh,
no, you're
please,
fine. I
never
just
stepped
need to
foot
make
in the
sure that I have
library,
the
you hooker.
right case that, and I believe I do.
And then I have another one after that that has the same type
All right.
of.
Give me just a minute. All right, counsel, for the record, the court has found the Ogilvy case that I believe she is referring to, which is 954 Southern Second
Yeah, Mandy, that's how I feel about them too.
698,
Yeah, I got it here too.
which is a first DCA opinion in 2007.
Okay.
No, I don't think so, Marielle. None of them have anything to do with anything.
All right, your
here.
next case.
One of them is about an appeal.
Logria, it's Logreira versus Logria.
You know when you read a word several times, but you never have to say it, and then when you have to say it, you realize you have no idea how it's pronounced, or you'll hear it pronounced, and you're like, "That's how you said," you know. Well, that's exactly what this sounds like with Sarah. She didn't even glance at this, and now she's trying to like sound it out and figure out what the fuck she's supposed to say, and yet she keeps on.
Don't know if I'm saying that name right.
You're not.
Sorry.
That's
All right, is that 322 Southern 3rd 155? Do you have that?
All I have, Your Honor, is 2021 third DCA.
All right, for counsel, I have that as 322 Southern 3rd 155, Florida 3rd DCA, June 2nd of 2021.
Got it. Thank you.
I'm sorry. I'm sorry.
No, you're doing fine. We just have to locate it based on what you're saying, and I just want to make sure that I have the correct case, okay?
Thank you.
So give me just a minute. I believe I found it, and I just need to make sure that I give counsel the
Correct,
citation that I'm looking at. So that's why it's taken a little bit of time, just so that he's on the same page, that he's looking at the same thing the court is looking at.
Yes, Your Honor, thank you.
All right, and why do you want the court to consider this Lagrera case?
Any restrictions must be court ordered based on evidence and accompanied by a fair hearing. Unilateral actions are ineffective and wrongful. It also emphasizes the need for due process before suspending parenting time.
Yes, La Boo Boo versus La Boo Boo. Friggin' Pope. Sonic
I have
versus
two more
Hedgehog.
after that, and I'm complete with it.
All right, give me just a minute.
Gail Marie asks why none of the jurors have spoken out. because God hates us. That's why. Joanne.
All right, the next case you have?
Of course, Kathleen.
Thank you. Perez, Perez versus Perez. And I have the citing.
Anyone
Okay,
else?
give me the citation.
769 SO2D 389 parentheses FLA 3D DCA 2000 in parentheses.
All right, that was 760.
No, 769.
Right, see, but we're still on the jury from the criminal case. We're bitter group of people here.
760. All right,
Guilty.
Do you
for
need the
counsel,
summary
the court,
part?
hold on a minute, ma'am, hold on. For counsel, the court has found the Deborah Perez versus Jorge M. Perez case at 769 Southern 2nd, 389, Florida 3rd DCA, 1999.
I found it.
I have
Hold on 1 minute, ma'am.
Maybe, Sophie. Or they sensed it. Hi.
All right, why do you want the court to consider the Perez case?
Because this underscores that restrictions on parenting time must serve the child's best interest, not a parent's convenience, retaliation, or preference. Also, courts require proper legal process and evidence, not unilateral actions to alter the parenting plan's time sharing term, regardless of where the parents are located.
All right, hold on just 1 minute.
Sophie Myers says, I pictured juror number 3 being a 70-year-old HVAC specialist who has never seen this kind of nonsense before in his life, and he's already over it, and he's got ACs to fix. Absolutely. I mean, that's not how I saw him. I didn't know how to see him, but now I do.
All right, you may continue.
Yes, please. If I could please add one more. I have 2 more and then I'm complete.
All right, go ahead.
Thank you. It's just stated as in regard to adoption of children by LAS, and the citation is 650, capital A is in apple,
Right, forget that.
2D, 214, in parentheses, 1994.
Yeah. How do you like this bitch, Nicole? Yeah, adoption of children, say Chris. I mean, that's what we're here for, right?
All right, that was 650A2D202.
214.
I know V. Lopez. I hope he does. And look at the time she's wasting. She's been told now a few times, I'm sure Judge Jackson knows exactly how many, that time is of the essence. And here she is, just things that she
I'm sorry,
didn't even
Judge.
write, doesn't even...
Yeah, we cannot find that case.
Yes, please, if I could put a substitution in.
Substitution.
You can do what?
This
May
is
I
a Wendy's.
substitute one for that? I have another one
Okay.
in place of.
Okay,
If I could just give you the citation,
yes, that's fine.
it's 996
Margarita.
SO2D 930.
Sorry to interrupt you, Sarah, but... Who was it? I just saw it. Hang on. Where are you? I just heard Stanley from The Office with juror number 3. I mean, yes. / HVAC specialist.
Parentheses SLA 2D DCA 2008 in parentheses.
Counsel, the court has found RE versus Department of Children and Families at 996 Southern 2nd, 929, Florida 4th DCA opinion from 2008.
Me too.
Got it.
RN2 moms. I mean, it's amazing. Unprecedented.
All right, and why do you want the court to consider this case?
Thank you, Your Honor. The court found that incarceration alone is
Oh,
not
yes,
ground for
Margarita.
termination
Thank
of
you. Of
parental
course,
rights.
yes.
And they still have the right to raise, contact, and participate in their child's life unless proven unfit on other grounds.
I really think that one of the reasons why true crime is popular, especially now, and why this case in particular brings so many people together is because politics, for example, as Gail Marie says, is like, no one wants to talk about that. We can all agree on this. She's horrible.
And one more.
Before you continue, hold on, before you continue, I have not heard any arguments or evidence that anybody's trying to terminate your rights. That's,
Forbid.
my understanding, that's not what's happening here. Is that correct?
Yeah, this is not a TPR proceeding. Yeah.
Got it. All right.
I mean, they've terminated your right to vote and your right to be free and your right to ever make a decision about anything ever again, but not your parental rights, so. Me too, Gail.
Hello?
All right. You said you have another case?
Of course she does.
All right, just, oh, actually, hold on, before you go, Ms. Boone, one of the, I don't know if you heard the court wanted clarification from
Probably
counsel
not
for
intentional.
petitioner based on everything that I've read and the testimony that I've heard here today, this is not an action to terminate your parental rights. Counsel confirmed for me that that is not what petitioner is seeking in this case. Okay, now you can go ahead with your next case.
Yes, please, if I may comment on that.
No.
It is in regards to me speaking to my son 1 day a week for 30 minutes, and
That
that's
is
what I'm trying
not
to.
terminate. I understand that, ma'am. What I'm saying to you is the case, and the court does understand, and there is a distinction between terminating parental rights and requesting a specific parental responsibility. So, you know, this case is not about terminating your parental rights. And the court is not considering a request to terminate your parental rights. But you can continue with your next case.
Okay, I'm just trying to clarify what my parental rights are. Speck v. Speck, SPECK. The citation is 225 SO 3D 319 parentheses FLA 3D DCA 2017.
So it's Brown versus State.
Speck v. Speck.
Okay, I need a citation one more time. I'm sorry.
Sure. 225 SO 3D 319 parentheses FLA 3D
All right, the court is
DCA.
not finding a
Yes,
Speck versus
Tamika.
Speck case. That is a citation for Brown versus State, which is a 2017 opinion regarding waiver of appeal arguments dealing with a sentencing order.
Okay, one moment, please, if I may.
You may not.
I'm looking through really quick.
Oh, here we go. Soon, I think.
Okay. I'm just trying to locate. Okay, Your Honor, forgive me, that's what I have for that one.
I'm sorry?
Okay, that's the 225, that's
Robin, we appreciate it so much. Thank you for your service. For real.
what I have for that, which apparently is
All right.
not right.
All right, any additional cases?
No, Your Honor,
All right,
for
all
that, no.
right. Any additional evidence you want the court to consider?
In regard to the parenting plan,
In regards to any of the issues that we're here on today that I have recited over and over, I think I might be on time number 7 now.
in regard to alimony, I would like please to add case law.
Okay?
Florida statute 61.14, I believe.
All right, repeat it for me, I'm sorry.
Yes, olive oil. Here we go.
Just one moment, I'm trying to make sure that I have everything pulled up.
Yeah. How would she know? It's not like she read through this or even wrote it.
Okay, I'm going to start, please. Would you like to have the citation?
A lot of them
Yes.
don't exist. A few of them don't exist.
39 SO 3D 453 SLA 2D DCA 2010.
All right, is that Malik versus Malik?
Grigsby versus Grigsby.
Oh, God. I'm not sure she's playing, Mandy. I'm not sure she's playing stupid.
Say the citation for me once again.
39 SO 3D 453
Okay, now say the name of the case for me.
Grigsby Grigsby.
Got it.
Does not have to do with alimony.
Details, man.
All right, the court has found Grisby versus Grisby at 39 Southern 3rd 453, which is a second DCA case from 2010. Dealing with the issues on sole parental responsibility, reestablishing time sharing.
This, I believe, was in regards to alimony.
It is not regarding alimony. All right, give me just a minute. We're going to have to go off the record for just a minute. We're going to take a 3 to 5 minute break.
This is not about alimony. It's about how many cattle you can own, you moron. I'll be right back. I think we have a... Hey, CJ. I think we have a few seconds. If you want to go, make a drink, call your mom. Me too, Esme. He really spelled it out very simply and briefly. You do not have to believe her. Can you hear me? There's no sound coming from this. It's on, but we're on a break because Sarah destroyed everything. All the batteries ran out in the whole building. Thank God, Dan. Thank you, Jackie. I'm never finished, Carolina.
Okay.
My laptop, because something happened
It
about
wasn't
4 or
playing, I was
5
wrong.
months ago, it only charges with a specific charger. And so my computer is telling me it's about to die. So my judicial assistant is running up.
It's clear. 3D453
Okay, now say the name of the case for me.
Grigsby, Gr.
Earlier, just so you know what's happening in the courtroom, I am in a different courtroom today. And even though my laptop has been plugged in
Thanks,
to
Carolina.
allow me to see on a separate screen, it was not charging due to a issue with my laptop that happened about 3 or 4 months ago. So now we have a charger for my laptop. I am back up and I am ready to take your next case citation regarding alimony.
Yes, Your Honor. Thank you very much. My next is Bowen, Bowen versus Bowen. And the citation 471 SO 2D 1274
None, Robin.
SLA 1985.
All right, give me the number after the 2D.
1274
Got it.
parentheses.
Okay.
Okay.
All right, for counsel, I have the Bowen versus Bowen case, 471 Southern 2nd, 1214, Florida Supreme Court, 1985.
I've got it. Thank you.
All right, go ahead, Ms. Boone.
Arrearages and alimony are vested rights and enforceable. While the court-ordered alimony period has now ended, the expiration of that period does not erase arrears that accrued while the order was active. Florida law is clear that past due alimony becomes a vested right, and the obligor remains responsible for payment regardless of whether the alimony term has since expired.
All right, anything else?
Right, V. Lopez. It's amazing.
Yes, I have. The citation is 418 SO2B 1113. It's Florida 5th DPA 1982.
Thank you, Olive Oil. You are a very good friend and a lovely person. Thank you.
And what's the case name?
Lamb versus Lamb.
All right, that was 418.
SO2D 1113.
And thank you very much, Janika. And give Sugar Bear and Sweet Pea a kiss for me, please.
All right, 418 Southern 2nd 213.
2D 1113. So 1113.
I'm not seeing that one. That site.
All right, give me the full site. Start with the first numbers again.
418.
418
I think she might be,
SO2D.
1.
Ravina, I think she might be losing those monkeys. And I told you there was plenty left here, right?
1 1
1,
3
3.
in parentheses Florida
Lamb versus lamb.
5th 5 CH DCA
All right, the court does not
1982.
find the Lamb case at this citation. 418 Southern 2nd, or do you say 2D or 3D?
2.
All right, that is not a citation for a case named Lamb.
Lamb versus Lamb.
All right, and I need you. How many more of these you have? We were down to 15 minutes, and I got to give counsel an opportunity to question you, and then save time for closing arguments.
I'm not sure. That's why being on the phone is very difficult. I'm sorry. I'm doing everything that I possibly can to properly represent myself.
Being on the phone is difficult. You're always on the phone. And you fucked everything up in person, too.
Lamb versus Lamb is not Bone versus Bone.
Again.
Tindall, Tindall.
Lamb versus lamb.
All right, give me the citation.
Killerer versus Killerer.
It's not on here. Forgive me. They did give
Exactly,
it to me.
Ravina. She can't even double check someone else's work. Oh, lamb versus
When
Zero shame on her.
All right,
550.
without a citation, the court cannot find a next case.
I'm sorry. My classifications department is speaking to me. Hold on one moment, please. I'm sorry.
No, shut up. She apologized.
Hello, excuse me,
It's a little late.
Your Honor.
Can we not see Judge
Hello, Your
Jackson
Honor.
now? How come?
Yes.
This is Classification Officer Santiago. I work at Will Correctional Institution. Due to our procedural operations over here, she's going to need to be off the phone at 4:50
Thank you,
in
Gail
5
Marie.
minutes. And I just thought that I would come on here and let you know.
Your Honor,
And
may.
then,
Thank you very much, Gail Marie. It's always good to have you here for this dumpster fire.
and then
Okay.
also for future court appearances,
I'm exhausted just thinking
they
about it.
are
Tanika.
requesting that communications go through the classification officer so that we can make sure that these, she has plenty of time to complete all of this so that we're not having to rush her off the phone.
Me
Great.
too, Robin.
Information was sent regarding this final hearing. And my office has been in contact with the Department of Corrections for quite some time over the last couple of months trying to get this set up because we had initially requested that she be transported to Orlando for this hearing. So there has
Right,
been contact. All right, but right now you are slow.
I also like that the prison wouldn't transport her. They were like, that bitch can do it from here. We had enough out of her.
Slowing us down and trying to get this finished. So give me just a minute. Hold on. Yes, counsel.
Your Honor, what I would suggest, I have no other questions for Ms.
Tamika.
Boone. So what I would suggest is
Rightfully
that
so.
perhaps the court allow both me and Ms. Boone to have a certain amount of days, not a super long amount of days, but a certain amount of days to provide written closing arguments to the court, and then the court can take the case under advisement and make a ruling, so we can get this done today.
All right.
She's so horrible. She
All right,
wants
so what the
everyone's
court is
time.
going to do is we're going to go ahead and finish up, I believe. Other than case law, Ms. Boone, did you have any other evidence that you wanted the court to consider?
Yes, I did. I had some other exhibits that I would like to have put into my evidence, and then I also was supposed to speak about the attorney's fees.
I've given you lots of time to speak about all the issues. The fact that you didn't take that opportunity instead of going into other issues is not what the court is going to address now. What specific exhibits do you would like to move into evidence?
Your Honor, forgive me, but I'm here on the phone
Forgive
trying to do
me
all
when
of
I
this.
ask you what other exhibits that you want to put into evidence.
My number 10, respondent's correspondence. I'm sorry, number 9, respondent. Motion for contempt.
All right, I'm not considering a motion for contempt with regard to a final hearing. Okay? Anything else?
It was my understanding it was held in continuance until this actual moment, which is why it's been waiting to be heard.
I think she's referencing, Your Honor, the motion for contempt on the non-payment of alimony, not the most recent motion for contempt that she filed.
Okay.
Yes,
Yeah.
this was
All right,
done,
the court will
and
take judicial notice that you have filed a motion for contempt with regard to the alimony. Okay? And that
And that
is
was back in
something that
2023.
that is something that I am considering because I've got to deal with what the alimony that was not paid, okay?
yes, Your
All
Honor.
right, so with that
I'm-
clarification from counsel, I will take judicial notice of your motion for contempt with regard to the alimony.
Okay. And then also the petitioner's account statements, which is my number 15.
Yeah, motion for contempt. Hi, Frank.
Okay.
She doesn't learn
Counsel,
anything.
this
It
looks
makes me
like
crazy.
truest
Or
bank
listen.
statements.
She always knows better.
No objection, Your Honor.
All right, hearing no objection, I will receive into evidence what was pre-marked as 15 as respondent's exhibit number 6.
Yes, Your Honor. And then number 21 through 25. Respondents, correspondence to judge regarding non-payment of alimony, parental alienation, and requests for case management conferences.
Or you get- All right. These are filings within the court. The court does not need to receive this as evidence.
Okay, if I may ask for judicial notice.
All right, the court will take judicial notice of
Right, Winter Lake.
documents that were filed on October 18th, 2022. January 31st, 2023.
There should be 5.
February 22nd, 2023. I do not see a filing date with regard to number 21.
They should be 2022 through 2023.
Ridiculous.
All right. For the record, council, Exhibit 20 is a notice of filing prepared by yourself. Looks like, again, filing some documents that you received. I think, oh no, this is notice for trial for 20. All right.
I'm going through it as well.
All right, so also court's going to take judicial notice of the notice for trial filed on, August 17th.
That's not part of my evidence. You may have gone one too far.
You just told me 21 through 23. All right, so that's 20, so we don't need that one. All right.
21 is respondent. 22 is
All right,
respondent.
exhibit number 24 is not indicating that I don't see anything on it that it was
Yes,
filed
Zach.
with the court, but it is a,
It was probably cut off from the copies that I had to obtain.
all right, the
Some
court
of
does
them
not
were-
need to take judicial notice of a request for case management conference, so the court will not take judicial notice. Anything else?
It's trying to show my exclusion in the case.
The court has ruled I am not taking judicial notice of a request for a case management conference. Anything else?
Number 27, 28, and 29.
Yeah, me too.
All right, 27, it looks like it's a letter dated March 2nd of 2023 to Attorney Martell. Any objection to this?
If it's a letter to me, it's self-serving hearsay, so I would object.
All right, I'm
It
gonna
makes her look worse. He shouldn't have objected.
sustain the objection as to exhibit number 27. I have a November 26, 2024 letter addressed to Attorney Joshua Martell as exhibit 28. Any objection?
Same objection, Your Honor.
Sustained. Number 29.
They are not wasting another minute on this if that they don't have to.
Appears to be handwritten letter to
I think so, Jenny.
Brian
Same court.
dated May 12th of 2024. Marked as exhibit number 29.
Same objection, Your Honor.
All right, sustained. All right, anything else?
Number 31,
Like Sophie says, if you
respondent's witnesses letter.
if you say to Sarah anything else, there will be something else.
So letter to whom it may concern.
These are my character witness letters.
Oh my God.
It's her what letter? I'm sorry.
Character witness letters.
Objection hearsay.
Sustained. Next.
They're actually laughing at her now.
Number 32,
She's her own worst enemy, Chris.
Number 32. current judgment interest rates.
Those are in regards to alimony arrears.
Disney Mom wants to know character witnesses from who? You know, the woman in the canteen, one of the guards. Who else?
If it's just reciting the statutory interest rates, no objection, Your Honor.
Abstain.
You review the document?
Let me see.
You
Can I-
object or you don't? Deputy, you could hand him this.
I haven't seen any of these exhibits, Your Honor. My apologies.
Tanika, I think he's busy, you know, telling people off and stuff.
No objection.
All right, hearing no objection, I'll receive into evidence what was pre-marked as 32 as respondents exhibit number 7. All right, anything else?
Number 35. I've got one more. And number 37. They're telling me I have to go.
Good. Bye.
All right, number
Exactly, Colleen.
35, you can approach counsel.
Okay, thank you.
It's like, come on.
Looks like something dealing with the canteen.
Of course, it's something dealing with the canteen.
It's the canteen items with current pricing.
She's really something.
Just for snacks for medical reasons.
We all need, I'm sure he has whiskey, Paige. But not for long.
All right, hearing no objection, I'll receive into evidence what was marked as number 35 as number 8 and what was marked as number 37 as respondents number 9.
Nicole
The
says,
JK communication features and current pricing.
Nicole says she has no one to pick up her stuff from storage, but she has character witnesses. Nicole, she got kicked out of her faith-based program in jail for bullying. So, yeah.
I think
All right, next.
the number 37, which is JK communication features.
We
and
already
the current
admitted that
pricing.
into evidence as exhibit number 9. Next.
Next.
Okay. And you have the GCL communication?
I have no idea what that is. If you, the next piece of evidence that you want
Good night,
to,
Zach.
next exhibit that you want to admit into evidence. Anything else?
Or good night,
I think we're
Jackie.
missing one because I'm going to put in the JK communication. I put in the GCL communication, but not the JK.
We have number 35 admitted into evidence as number 8, number 37 admitted into evidence
Good night, Tina. Good night, everyone who's leaving us now. Sleep well. See you soon.
as number 9. Next.
Number 36.
Taking a look at this, Your Honor.
You can stay it.
Right, Robin. And he will, and he'll sell them on eBay if possible. Pretty much.
All right,
I mean, who
receive into
knows?
evidence what was pre-marked as 36 as respondents exhibit number 10,
Good night, John Boy.
which is also
Yes,
a
Your Honor.
J letter. Next.
That's all I have for right now, Your Honor. I'm being rushed out.
Good.
All right,
I wouldn't call this
I'm going to give
rushed.
you all until next Monday at 5. I'm going to say by 5 p.m. That includes, Ms. Boone, you need to put it in the mail by next Monday, a written closing argument on the issues we're here on today. Okay?
Good night, Dandy. Thank you.
So I'm going to give you all until 1 week to provide written closing arguments No more than 5 pages.
No more than 5 pages?
That is correct.
Parenting plan, alimony, attorney's fees.
Counsel?
Can I submit real quick 2 exhibits before we end?
All right, what are they?
I just have, these are more for demonstrative purposes, but I have my proposed child support guidelines worksheet that was marked for identification purposes as petitioners B, and then my case law, which is in hard copy form marked for identification purposes as Exhibit C. This is all
Or what was the child support guidelines? Was it pre-marked as?
B.
B as in boy, and then the case law as C.
C.
All right. Ms. Boone, do you have any objection to what was pre-marked as petitioner's exhibit B or C, the child support guidelines or case law?
No, if someone explains it to me though, if we have a chance to, I don't understand it.
No kidding.
All right, hearing no objection, I'll receive into evidence
it
what
up.
was pre-marked as B as petitioner's number 4 and what was pre-marked as C as petitioner's number 5.
Please, if I may, before we hang up, the closing arguments are for parenting plan, alimony, attorney's fees, and.
I am not
Middle-
repeating myself, ma'am. You need to make a closing statement. You need to put it in the mail to me no later than next Monday, which I believe, actually, that's a holiday. So I'm going to give you all till Tuesday, which is September 2nd. I will not accept anything that is postmarked beyond September 2nd. Again, this is closing arguments on the issues we're here on in trial today. No more than 5 pages. Thank you and have a great day.
And there we have it. And sirens, just to complete.